Order members, welcome to the 39th meeting of the Committee for Justice. The meeting is now open to the public. Please be aware that the meeting will be recorded and broadcast throughout Parliament buildings and online. It's proposed that the oral evidence session with the Law Society of Northern Ireland on the Justice Bill will be recorded by Hansard. Are members agreed? Thank you. Members, we're obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence our approach to matters under consideration. Anybody who's got an interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Does anybody have any interest they wish to declare at this stage?
As a member of the All-Party Group.
Thank
Access
you.
to justice.
Same for me.
Immediate family works in the probation board.
Thank you, Danny. And I have an immediate family member who works in the legal profession, so I think that's everything covered. And there are a number of us who are members of the APG. So, right. Apologies then, I don't have any. We've got a full house, and you can see that we have Doug Beattie and Justin McNulty with us virtually. Draft minutes of the meeting held on Thursday the 8th of May, which was last week, are at pages 5 to 15 of the pack. Are members content that those minutes are a true and accurate reflection of that meeting? Yes? Then I'll sign the minutes. Thank you. Matters arising, we don't have any. Does anybody else? No? Thank you. Agenda item 4 then is the Justice Bill, and it's going to be oral evidence from the Law Society of Northern Ireland, and I would ask members to turn to pages 17 to 39 of their packs. Maybe slightly ahead of schedule, so they might not be here yet.
All right.
Members, this might be an opportune time if you want to refresh your tea or coffee, or just while we're waiting for our witnesses to come in. It's a good fun.
There's lots going on, even if you're not really in the farming or
I hear
whatever, because I don't have a clue.
It's like it's a good day, right?
Yeah. So there's
We're
good
not the
food
same
on
store,
it.
we
so-
never got out and about, do you know what I mean?
Yeah.
But you really better get up just and get in the day, like.
Joe and Owen are going to come
Better than being in here and doing emails. Like.
here. Is it one?
Oh, good lord. Okay. Okay. Right, so it's the first day.
Do you want to take like something else already, or
Yeah, we can move on. Yeah.
That's fine. We can. Members, you can tell there's a medical issue with a witness, so we're going to just, if we can move on through the agenda for now, if you're agreed, and then we'll come back to the Law Society. Will that be all right? Thank you. Agenda item 5 is Justice Bill written papers. Members, I would ask you to turn to, first of all, we're going to do 5.1. So that's the clerk's memo, and it's an update on written and oral evidence on the Justice Bill. I would ask you to turn to pages 41 to 48 of your meeting pack, and it provides an update on the written and oral evidence received thus far on the bill. So let's just get to the right page. Voipic and Include Youth have requested an opportunity to provide oral evidence to the committee in advance of our event with the young people, which is going to be held in the Long Gallery on the 3rd of July. Our members agreed to schedule an oral session from somewhere between mid to late June with Voipic and Include Youth.
Yeah.
Yeah,
It's very good, yeah.
that's okay, good. Members, then you'll see from this correspondence and the lists that we have, you'll have seen who we've received written evidence from, who we've received oral evidence from, and the subject matters on which they have touched. Can I ask for your views on whether there's other organisations or individuals you would like the committee to invite to provide oral evidence on the Justice Bill, or if there are specific people you want to hear from in writing that may lead on to oral evidence? You may want to highlight areas where you believe there are gaps or where additional evidence is required on particular issues. I'll be honest, I am conscious that we have focused considerably on biometrics. I don't think we've exhausted it yet, but I think we've focused considerably on biometrics. I think we have focused considerably on children, even in issues where it's not just children who are impacted. And I would like us to broaden our scope to make sure that we are covering other aspects of the bill. Certainly my initial thought is we haven't heard anything on the restorative justice side, and we haven't received a written paper, so I would like us to write to the community-based restorative justice practitioners to seek their views in writing on the amendments that are proposed. That would be kind of my initial thought. I appreciate we have not yet had legal advice on each aspect of the bill, and we're working our way through that, and as we get that, gaps may also arise and there'll be issues we wish to take forward, but I'm just conscious that we have really focused in on a couple of issues, and those are very complex and we're still not done yet, but I do want us to try and broaden our scope where we can. Members have seen those papers, so just a reminder then, there's an informal roundtable event with grassroots community organisations. That's going to be in the Long Gallery on the 5th of June. And organisations have been asked to respond to confirm their attendance by tomorrow, which is Friday the 16th of May. So in light of, I suppose, all that you have in front of you and the issues that I've raised there, are there any specific parts of the bill or planned amendments that you wish to explore during the discussions at the events?
I suppose I was going to agree anyway in terms of the restorative justice ones, because that is a gap at the moment, and I'll bring the other bit up on the other written papers or the info that came from the policing board, because I think even potentially the human rights advisor, which I know they travel in, so whether that could even be something on Zoom in terms of the contents that they've raised, I think it would be useful. And as you say, there may be other issues with even some of the written evidence that we may want clarity on as we kind of start to move through it in a bit more detail. But I think the big gap for me at the moment is the restorative justice that you've highlighted.
Okay, so first of all then, are members content that we would seek the views of community-based restorative justice practitioners for their views in writing initially, and then we can determine if we need to hear anything further from them? Yeah?
Yeah.
And then the next thing is, are you content then that we would hear from John Wadham, the Policing Board's Human Rights Advisor? Yeah?
Great. Yes.
Okay. Does anybody have any other gaps that they're kind of conscious of, worried about? Anything they'd like us to take note of? Anybody you want to hear from that you haven't seen on those lists?
I don't know, the only thing, sorry Chair, around, I suppose it's the live links. While I agree with the broad thrust, it was just the issue in terms of vulnerable categories, and I don't know, maybe it's been already kind of reflected in some of the organisations that have responded. But just making sure then as we're moving through the amendments and stuff in terms of live links that there's those safeguards in place, but maybe we can come back to it. I can't think of a specific group, I suppose that's the issue. Or individual experience. Maybe we'll get that through some of the community engagements and then we could come back. And obviously the bit around the taxation, I mean, I know we're going to get the presentation today, but obviously in the absence of the judiciary on that part, it's a bit difficult then too.
Yeah, the taxation issue is difficult, I think. Right, well, at least that gives us a steer for now. Can members maybe give some consideration to that over the next couple of weeks? The forward work programme will outline roughly where, Kathy and I had a conversation today, and we're going to try and get as much of the legal advice in as we can, and that'll help us to establish where the gaps are and what else we might need to hear, you know. Deirdre?
It's just as I looked at it there, but just even around, might not need an oral briefing or anything, but just even to broaden our awareness around the Access NI kind of checks and the filtering element of that, because obviously that's going to come up as well. But maybe we can consider that at a follow-up meeting, whether we feel, you know, for Access NI to kind of give us an overview maybe on how that works, what the proposals would mean in practice. Because obviously those checks are something that continually comes up, you know, across the board. So, and obviously they're important safeguards. So it's just making sure that we have a complete understanding then of the filtering processes as we get to that point of considering, you know, the amendments and stuff.
Sorry, Kathy?
From Access
Access NI
Access
themselves.
NI themselves then? For that?
Yeah, because they would be the ones. I don't know
Yeah,
what
look,
others think.
It strikes me, I'm not sure we've covered all of our, I'm not really sure we've covered the ground we need to on serious organised crime.
Yeah.
So I think we'll need to look at that, and I suspect there'll need to be further conversations with the police about that. Restorative justice we've dealt with. Rehabilitation of offenders, I think probably we need to do a bit of work on that too. Access NI you've touched on. The repeal of vagrancy, I think yes, there are issues in there. I think we all get the point. But as with every bill, part of our responsibility is to make sure that we're looking, and this is, I want us to be very clear about this on each aspect of the bill. What are the practical implications? What are the ramifications? You know, how does this work in practice? You know, from moving from the words that are on the page to how's this going to work in everyday life. And I think we need to work through some of that with the biometrics and all of these things. That's the stuff we need to be looking at, because that only then can we consider the unintended consequences that there may be. So, and I think there's certainly some of that in repeal of vagrancy, and we had heard that at a time Glasgow and Aberdeen councils, I think, objected at the time. I would like to understand what their objections were and whether or not, since the legislation has been implemented, how they have found that. I think that would be helpful for us, yeah. Because, look, we all get, nobody should be criminalised for being homeless. That's a given. But the issue is then, okay, well, we need to make sure, you know, we're covered in that. Life links the same issues. The Law Society in their paper raise matters of disability, you know, people who are hard of hearing and those kinds of issues, just to make sure that we've covered things there and how those practical things work out for them. So, yeah, I think we've got scope on a number of issues to look at, consider in more detail, and ask some broader questions and also some more detailed questions, I think. As we move through this, because I think the stuff that we've heard now is kind of general principles of things, but now we need to understand the workings. That's my view anyway, and I consider that to be part of our responsibility. So if members can give some consideration to those issues, this will not be the last time we'll look at it. Is that okay? Yeah. Thank you. The witnesses are here. Okay, let me just... Right, I'll just work through.
Do you want to go through those?
Yes, I'm just going to finish off. If there's anything else that occurs to you in the interim period, I suppose over the next couple of weeks, can you email that in to the team, so that, I mean, beyond the issues that we've raised here, anything that's raised here is already taken as read then, but if there's anything else, can you factor that in? Just briefly then, members, if we can finish off item 5, and then we'll return to the evidence from the Law Society. Item 5.2 is the Northern Ireland Policing Board, and it's further information. You'll find that at pages 49 to 336 of your meeting pack. You'll see that the board has provided follow-up information on a number of matters further to the evidence session on the 1st of May. Are you content to note these papers, or do you require any further information or clarification? Deirdre?
It's just to say, I mean, it's an extensive pack
It is.
that they've given us. And I suppose it's, well, within that's hidden the answers to the questions that we've asked. But I think I know we've already agreed to get the human rights advisor in, because I think there's some real detailed and important stuff there. And I suppose it's that balance around Article 8 rights in terms of privacy and life. And also for me, they highlighted the issue around a lack of consultation by the different agencies in this matter. So I think it would be good when we get that oral session with them, just to kind of get into the detail of the papers that they've given us.
Yeah, members agreed?
Yeah.
Yeah.
Chair, through
Yes,
you,
Marcus.
I found that a very lengthy document, and I
Yes.
think the details between the lines, not actually on the lines, and Deirdre's right, there's a lot of questions in there that need to be answered. Can we give the questions in advance? Can we provide some of the queries that we have in advance to have that oral briefing?
Yes, without question, probably would be helpful and might help us to expedite the discussion.
Here, would it also be, I thought it was really, really interesting, obviously Police Scotland and that, the data ethics framework that they've set up. It would be really good to see if we could get a copy of it or a summary of it. Or
Yep. So members agreed to that we would seek that? Yep, thank you. Item 5.3 then is request for further information. I'd ask you to turn to pages 337 to 359 of the pack. You'll see the committee team has collated a list of the committee's requests for information on the Justice Bill and the responses received to date. Are you content to note that?
Noted.
For now, yeah, that's going to be updated every week. So, and that's a really useful document, so thank you very much to the team for that. Right, that's agenda item 5 dealt with. Now if members are agreed, then we can return to the evidence session from the Law Society. Members, we have with us Owen McKenna and Joe McVeigh, who are both practitioners. Gents, you're very welcome. Thank you very much for taking the time. We appreciate that Peter and Brian were due to be with us. We understand that there has been a situation,
Yes.
and we wish Brian well and a speedy recovery, and we trust that that'll be resolved. If you get any updates in the course of the meeting, we'd be grateful to hear that everything's okay.
Of course, thank you.
Thank you very much. Gents, the general format of this is going to be, I'm going to hand over to you. We've received your written paper. I'll hand over to you for any kind of additional remarks you wish to make, probably 10-15 minutes worth. And then the intention would be that in terms of questions from members, we will work through the sections of the bill itself. Then any issues there may be pertaining to amendments, any other issues that you have addressed in your paper or your oral briefing, and then any general queries that we have. Does that work for you?
Yes.
Yes, thank you.
Just rather than jump about on subjects, we'd rather try and keep things structured in that way. Is that okay?
Yep, that's absolutely no
Perfect.
problem.
On that basis then, gents, over to you. Thank you.
Right, so Madam Chairperson, Committee, thank you for the invite to attend here today. The bill itself is vast, very complicated, so the person who drafted it had quite a piece of work to do, and so we understand that, as you've said, you've received a copy of the Society's written submission. So I suppose for our purposes this afternoon we intend to provide some initial remarks which will be centred around the key issues, which were biometrics, the children's provisions, live links and taxation. So my focus will be on the biometrics and the provisions within Part 1 of the bill, a complex and evolving area that directly engages Article 8 of our Convention rights, where the balance has to be struck between individual rights and the legitimate aims of the state, particularly in the detection and the prevention of crime. Within the bill, biometrics, it would seem, is rather narrowly defined and is limited to fingerprints and DNA. Now, I would respectfully submit on behalf of the Law Society that no longer reflects today's technological landscape, where biometrics have vastly advanced with tools such as facial recognition, iris scans, your behavioural identifiers like gait, that sort of thing, already in use by some people in law enforcement in other jurisdictions. And so the tools available will undoubtedly continue to evolve in the years ahead. And so a broader and a more future-proof definition of biometrics might, we would respectfully submit, be needed within this bill. Additionally, on future-proofing the legislation, the provision for the Northern Ireland Commissioner for the retention of biometric material to keep emerging technologies under review is important. However, the Commissioner's role needs to be clearly defined, particularly to avoid duplication or overlap with other bodies, for example, the Information Commissioner's responsibilities. So in respect of the proposed new retention model, the Society welcomes the move away from the indefinite retention period towards the creation of maximum retention periods. This will help to align Northern Ireland with the standards across neighbouring jurisdictions, as well as with key legal judgments which were set out in our submission. And the committee will be aware of those judgments. It's necessary to ensure that the new retention model appropriately balances the aims of detection and prevention of crime and the right to private and family life, considers the seriousness of offences committed and the need to retain data, provides an opportunity for an individual to challenge the continued retention of their biometrics, and reflects reoffending patterns. On the proposed amendment in respect of a statutory power of the PSNI to require a person to return to a police station later for a photograph, the proposal to specify an exact time and place may be too rigid, and a more flexible time frame may be more practical. Lastly, it must be recognised that previous attempts to introduce legislation in this area faced delay due to the concerns about how reforms might impact unresolved troubles-related investigations, and it will be important to consider the interlink between the provisions in this bill and legacy cases, particularly in the context of the UK government's new plans to address the legacy of the past in Northern Ireland. So, in summary, the Law Society welcomed the shift away from indefinite biometric retention and would emphasise the need for a balanced regime, one that enables effective law enforcement, but not at the cost of fundamental rights. And so, unless the committee wants to address biometrics as a standalone issue, I could hand over to Owen McKenna and he could have his opening remarks on the rest of the
So we'll
oral
hear from
evidence.
you and then we'll just open to questions.
Thank you. I will focus my remarks firstly on part 2 of the bill on the bail and custody arrangements relating to children, then deal with live links and in due course, and then deal with the taxation elements. In relation to the child custody arrangements, evidence shows that early contact with the justice system can lead to a revolving door effect for children, largely due to the complex backgrounds of children who encounter the criminal justice system. Solicitors play a critical role in supporting children through the arrest, bail and custody process by ensuring they understand their rights, conditions of their bail and decisions being made by the police and courts. Given the complexity of these proceedings and the vulnerability of many children involved, who often have additional needs, access to legal advice is essential to safeguard their rights and promote fair outcomes. Clauses 4 and 5 do introduce new requirements for custody officers. However, disparity between police and court powers remain, which have contributed to an overuse of short-term juvenile detentions. This should be further addressed, we believe. A key area of concern is that children are frequently remanded due to a lack of suitable accommodation, not risk. There is therefore an urgent need for suitable short and longer term emergency accommodation to ensure that children are not remanded in custody unnecessarily. Bail support services should also be expanded and made available to all children, including support for parents and carers also. This will require this additional resourcing and investment we appreciate. On places of detention, the Society welcomes the clarification in law that children should not be detained with adults, as well as the increased maximum age for youth detention centres, along with the removal of custody care orders for children under 14. In summary, while we support many of the reforms, it is important that protecting children's rights within the justice system is a top priority, and that international best practice and standards are always adhered to in relation to custody and bail arrangements relating to children. Turning to Part 3 of the Bill, the Society welcomes the inclusion of clauses 20 and 21, which formalises the use of live links for police interviews and extensions of detention. Remote attendance by solicitors and clients has proven beneficial and has helped to reduce delay, travel and waiting times. Within remote processes, it is critical that the rights of interviewees and detainees are still fully upheld. This includes access to confidential legal consultation and medical advice, in particular while in custody. It appears that appropriate safeguards have been put in place to protect the rights of detainees. However, it is vital that access to legal advice is ensured at all stages of the process and practice matches the theory. Codes of practice must be updated to reflect the changes within the bill. They should include an obligation for documents to be supplied to a representative involved in the process via remote means, as well as ensuring that legal representatives are kept informed so that representations can be made before key decisions are made. Finally, there should be further investment in technology to ensure the quality of internet connectivity in custody suites is assured so that interviews are conducted to a satisfactory standard where all participants are visibly identifiable and can be clearly heard and understood. In respect of live links more broadly across the courts and tribunal system, placing live links on a permanent legislative footing is both an important and welcome development. Since the COVID pandemic, the benefits of remote hearings for all court users, efficiency, flexibility and improved access have become clear. Proceedings such as administrative proceedings, remands in criminal courts and case management hearings are well suited to this format. That said, such other situations such as fully contested hearings and jury trials should remain in person, as was the norm previously. The Society supports the presumption in favour of using live links in certain cases and would support the expansion of this to other suitable hearings. The Society also welcomes the proposed amendment, which will insert a legislative obligation to have regard to guidance issued by the Lady Chief Justice, as well as the requirement for the court or tribunal to provide reasons why it has refused an application for a direction. Consistency in applying the interests of justice test is crucial. This will help to alleviate inconsistencies reported to the Society of differences in approach across different court tiers and areas, and will lead to increased uniformity and predictability across the system, which is vital for all concerned. The Society fully supports the principle of open justice and agrees that permitting the public to see and hear proceedings through limited transmissions and broadcasts when appropriate can enhance transparency. However, this must be supported by adequate digital infrastructure to prevent disruption, especially in high-profile cases. And finally, we would like to emphasise the need for continued investment in technology and ongoing consultation with practitioners to ensure fairness, consistency, accessibility and systems resilience. If I may move on to taxation, please. I will focus my remarks on clause 28 in the bill, which is a major concern to the Society and its members. It appears to be an attempt to restrict or remove the role of the taxing master in legal aid cases, which would be a significant departure from current practice. The current process of taxation is transparent, is fair and is robust. Solicitors prepare a detailed, itemised bill setting out line by line the work they have undertaken and the disbursements incurred by them. This details every step taken in the case to include, for example, all attendance with clients and their witnesses, all correspondence and telephone calls in and out, the instruction of experts, consultations and attendances at court. Vouching documentation is also required to be lodged in relation to any disbursements and court orders made. The taxing master scrutinises every element of the bill of costs carefully, ensuring that costs are justified. The taxing master is an independent judicial office holder, subject to standards and court rules, and is ultimately accountable to the Lady Chief Justice. Restricting or removing this role would reduce judicial oversight and would undermine the fairness and independence of the process. Taxation is and remains a feature of legal aid systems in other common law jurisdictions, such as England and Wales, where cost judges play an important role in maintaining independent oversight. In Scotland, where the Auditor of Court will assess bills for taxation, and in the Republic of Ireland, where the Office of the Legal Costs Adjudicator, formerly known as the Taxing Master's Office, assesses bills of costs. It is therefore questionable why an approach would be taken in this jurisdiction to create a more restrictive and less transparent approach. Moreover, it is important to highlight that the current system already has reliable built-in safeguards. For example, there is a provision to appeal to a High Court judge, and the Legal Services Agency has processes in place to flag high-cost cases and liaises regularly with the Office of the Taxing Master. Furthermore, taxation is included as one of the pillars within the Department of Justice's Enabling Access to Justice Reform Programme, and work around this is at an early stage. The explanatory memorandum suggests that Clause 28 will be commenced on a project-by-project basis, but there is a lack of clarity on when, how, or what these projects may be. We therefore consider that the inclusion of this clause is premature and should be removed from the bill. Legislation should only be brought forward after the correct sequencing of developing proposals, consultation, review, and ability to properly debate and scrutinise provisions. In conclusion, legal aid is a demand-led area, with costs fluctuating depending on the number of cases within the system. There is no clear evidence that Clause 28 would improve accountability or cost predictability. We therefore recommend that Clause 28 should be removed from the bill. That concludes our presentations, and we would be happy to take any questions on any of the areas covered. Thank you.
Thank you, Johan. Thank you very much, Joe. Right. We'll just move through this then as we discussed, if that's all right. Members are okay with that? Yeah. Right. Biometrics, let's start there. So that's you, Joe, you're up.
Okay.
Right, so we've got on this one Deirdre, Ciara and Morris, and then I probably have a couple of things in there too. Deirdre, I'll start with you.
Yeah, no, and thanks very much
Deirdre, don't be making it technical.
for your presentation. I'll try. I'm hoping you will make it technical. No, it's just obviously, I mean, I would have the same concerns in terms of the narrow scope of what biometric data is, and obviously we heard from the Scottish Biometrics Commissioner, and even the PSNI themselves hold 180,000 photographs already, and if that wasn't treated as biometric, so I know you said it needs to be much broader than fingerprints and DNA. You've talked about obviously facial recognition, and the Lovelace Institute have raised those concerns as well. So it's just to see what other areas potentially you feel should be included, and should there be a flexibility for any new emerging technology that maybe isn't here yet, to ensure that we do have flexibility in the legislation going forward.
So the provision for regulations for the Commissioner probably gives the opportunity for ongoing flexibility moving forward from the Act when it comes into law. But I suppose what the Law Society might say is that we would prefer to try and do it correctly the first time around, and not necessarily rely on regulations for things that we can see are just sort of up the track a little bit and coming in. And when we consider, for example, I'm sure you've seen in the media in America recently, a victim impact statement from a deceased person was given in court. And there was, because this type of technology using AI is very cheap now, and it probably makes it more possible and more attractive to manipulate photographs and video of people in order to respond to whatever objective the police might have in terms of investigating crime. And so therefore, knowing that that's available now and cheap now, the legislation should probably take it into account right away. And we've been using voice analysis, etc., for a long time in the criminal justice system, and therefore retaining samples of people's voices. However, and also having rules around how it is you obtain those samples. So we've seen, for example, prisoners' phone calls being recorded and used for voice analysis in a trial. So if you think of it this way, post-charge, someone's voice being harvested by investigators in order to be used for voice analysis later on. So there needs to be strict rules around how that's done, because, for example, if I'm on the phone to someone and someone's listening to that call, I'm not the only person on that call. Someone else is expressing their feelings, talking about their family, talking about their children, etc. And so there needs to be rules in which we harvest this type of information and retain it. And this is an opportunity maybe for this bill to reflect what's already in practice. These are not investigative opportunities taken routinely. I'm not suggesting that everybody's subjected to this, but where it happens in important cases. And so therefore it should be, and then for how long those samples are retained is important, I think, as well. So, for example, there's other data. So police will recover information from mobile phones, and they will, I have one case, I'll not say who the defendant was, but I had cause to write to the PPS asking for the data to be deleted. The person was acquitted, and on that hard drive that was served on us, there were intimate photographs removed from the phone of this person and his partner. And I was told, in no uncertain terms, that it could not be deleted. None of it. It had to be held because it had been obtained as evidence as part of a prosecution. So there was a third party whose intimate images are still retained by the police and the PPS. So when we talk about retaining data on a suspect, we don't just retain data on a suspect if we harvest the information from their phone. We retain data on every image, every voice message, everything that's on that phone. So these are things worth considering as part when we're talking about biometrics, because all of this is subject to being processed electronically for another purpose. So it's important, in my respectful submission to the committee, that we broaden out the protections. The other thing is this: if we don't include protections in this particular bill, and think, well, we can always cover that later in regulations, people are going to fall into that lacuna. At the minute, where they'll have no protection, and so they might get a protection later on in the future at some point, but they won't have those protections now. If all this pertains to DNA and fingerprints, which is really 20th century biometrics, really. So I hope, Deirdre, that
Oh, it
does something towards answering that question.
Because it feeds into my other point, and it is around the safeguards, as you point out, and the review mechanisms. And I suppose some of the concerns that have been highlighted is that some of the provisions are in subsequent regulations and not in the face of the bill, and therefore you can't strike that balance or even to assess the balance. So I suppose it's just whether you would share the same concern, and also I suppose the scope or looking at the role of a biometrics commissioner. You know, is there any more information or areas that you feel we should be looking at? Because obviously one of the concerns, even the Policing Board's human rights advisor has raised serious concerns around a lack of consultation in terms of issues of privacy, so the Article 8 rights. And I suppose what we're trying to grapple with is that balance, obviously, in terms of the protection of those rights, but obviously also the duty on states in terms of safeguarding and dealing with crime. So I was going to ask as well, the Scottish Commissioner's Office, pertaining particularly to younger people as well, and the whole issue around stigmatisation of young people, where they don't retain the data unless it's a serious offence. So it's just to see as well if the Society have any views on that.
Well, that sounds eminently sensible because you're dealing with young people. And as I think one American politician said, when I was young and foolish, I was young and foolish. And therefore, there should be a caution, both in society generally, but by our lawmakers, in how it is we harvest information about children. I'm also maybe going to say this, and it's not in the Law Society's submission, but you know the courts make a particular difference for people who are 18 to 21 as well, and this legislation seems to suggest that adulthood or childhood just falls off a cliff at 18, and we know that's not true. And in actual fact, I can see in the future how we will evolve the criminal justice system to take into account the development of young minds up even until the age of 25. And so the idea that we stop at 18 and that's when childhood stops, when we know any of us who are rearing anybody who's over 18, the childhood does not stop at 18. And in actual fact, we need to respect the fact that certainly people up until the age of 21, there should be consideration given to treating them differently from people who are fully adult. And in actual fact, we do that in the criminal justice system. We have a young offender centre. We don't send 18-year-olds to Maghaberry. We treat them differently. So there is scope for treating younger people differently. I would also maybe say this about the bill. The bill doesn't seem to provide for P, the person, to actively instigate a review. So the Chief Constable can review, and I suspect the Commissioner can seek a review of, no doubt the regulations will provide for that. But the person whose data is retained is not able to say, I would like a review. So, where is a good analogy for that? If you commit a motoring offence, you can apply at a certain point to have your disqualification, let's call it what's properly called the restoration of your driver's licence. So, of course, there are minimum periods where you can do that. So you have to see out the statutory minimum disqualification. So that's number one. Number two, you can only go back at the halfway mark, I think. And even at that, there's so many years you have to do before you can apply to restore your driver's licence. And it struck me when I read the legislation that there could be safeguards put in place in terms of the provision of powers for police to investigate crime, where P can return after a specified time. So not just straight through the door after 12 months, but coming back after a specified time to say, look, I think the circumstances are such that you no longer need to retain my fingerprints or my photograph or my DNA or my voice sample or video clip you have of me or whatever it turns out to be. And because then it puts the responsibility on the state to continue to justify the retention, which is where that responsibility should firmly lie. It should not be for P to justify why things shouldn't be retained, but they probably would have to do that in the course of an application anyway, practically speaking. But the state should always have its feet put to the fire in terms of retaining private, intimate information about a member of the public. So the fact that there's no facility in the bill to instigate would raise concerns about its compliance. I also would say this: it will be a cause of litigation, in my suspicion, if it isn't included. So in a way, leaving it out is legislating for litigation. So I thought maybe I would say that in terms of the provisions in Scotland, we have a code of practice, and I don't see a code of practice in this bill. That's important because, as a lawyer who has judicially reviewed all the way to the UK Supreme Court on the absence of a code of practice in terms of directed surveillance, codes of practice are important because they set out the landscape clearly as to how everybody knows things are being done. And if I am representing someone and I don't know what the rules were that were applied, and in actual fact the investigators don't know that there are any rules, in fact there aren't any rules, so they're working without rules, then it makes it very, very hard to understand how the law is being applied. It makes it very difficult to advise people about their rights. So the code of practice is essential, actually, to do this right. That will result in litigation.
I'm fairly sure we've raised that actually with the department.
Yeah.
Code of practice for the commission.
Yep. So I thought it was interesting that they had that, but on the sort of wider point about serious offences for children in Scotland, I think that society would agree that that is, in terms of proportionality, that's the correct way forward in dealing with children.
Thank you very much. That's useful. That's
Okay. Ciara?
To be honest, you've basically covered all the area. There's just one wee final one. You noted just in relation to when you have the kind of stipulation returning to the police station to take a photograph, for instance, and they're basically going to specify time and date, and you noted there should be more flexibility. Could you just, given the practicalities of it all, could you just throw some light on that as well?
Yes. So, Ciara, the way it would work is at present. I suspect the way it would probably work in the future, but we're not legislating for, relationships between lawyers and police. So if something's going to be in the legislation, it needs to be there. So the practicalities of people returning. So who returns for photographs to be taken? Who returns for DNA or fingerprints to be taken? They tend to be people who voluntarily attended at the police station, who then were prosecuted under summons and convicted. They have to return, because if you were charged, your fingerprint, your photograph, and your DNA are taken. So these are people who were summoned and were convicted on foot of a summons. But there'll also be people that, when we look at the legislation, who will have one of these fines that the prosecution can impose because they'll not have been to court. So there are people who maybe have to turn up and subject themselves to DNA, fingerprints, and photographs being taken. But where we are at the moment is often we'll say to a police officer, they'll contact us and say, look, your client needs to come in and have the photograph taken. Well, they don't say that yet, but they'll say fingerprints taken or DNA. And we'll say, okay, all right, well, look, they're on holiday at the minute. Would you maybe suggest when they come in, well, look, if they drop in, I'll be on nights this week. Give them my mobile number and they can arrange to give me a call and I'll take their prints or whatever. In other words, there's a huge amount of flexibility that works around people. So why? Because it's an offence not to provide it. So no one wants to criminalise someone who has been dealt with by way of a summons, for, I don't know, shoplifting or something like that, and they don't want to criminalise them further for not popping in to give their DNA or fingerprints. So the police are very practical about that. Whereas if we have something which is prescriptive, you could end up with people failing to turn up, and then a police officer saying, look, it was an offence for you not to turn up to provide that.
I think, in fairness to the department on this one, I think that's what they're aiming for, Joe, because I think what they're saying is there's a number of police stations that are closing,
Yeah.
a number have closed. They're concerned that if people just rock up without arrangement, then the person who deals with the photos and taking the DNA may not be there. So actually, there's potential for the clients to be inconvenienced also.
Yeah.
So the impression that I got about this, I absolutely see what you're saying, and maybe we need to tie that down a bit further. But the impression that I got from them putting this in was to try and make sure that actually the flexibility is codified to allow people a chance to come and that they're not inconvenienced, that it can be arranged.
Well, if there's flexibility in the system and it allows for people to make arrangements, and the police and the
Yeah.
MP
Yeah.
aren't inconvenienced, because if we reflect on the seriousness of the offence, most people who are dealt with by way of summons, they weren't charged because it wasn't deemed to be that person wasn't deemed to be someone who needed bail conditions or to be brought before the court within 28 days or overnight. So if you consider that, this is someone who, in many respects, the police and the prosecution have taken a relatively light touch with already.
Mm-hmm.
So we don't need to be heavy on our touch with them after they're convicted.
Is that everybody else's recollection of what we've heard from the department? I mean, that was...
I didn't get that recollection from the department now, to be honest. I thought it was more, I suppose it was solely down to resource issue, and it shouldn't be when it comes to improving the flexibility. Because I've never heard, I'd love to hear where's the evidence that it came. If it's solely down to resource, as you say, if stations are closing down and they don't have the resources, so this is to suit everybody. But I've never came across it where there isn't always been that flexibility regarding working with a solicitor, with an individual, with the local police, and creating a convenient time. So I would love to know where the evidence is and what's...
Because my interpretation was I nearly thought it was the police nearly asking for a more specific time. I just have a concern that what's there in the bill is too rigid. If it's only
Yeah.
one time, I mean, I can get you don't want to leave it so open, and if
It
they're
didn't
not there,
ever
it is a
work
waste
when.
of the person's time
Yep.
and the police. But is there flexibility not to be so rigid with one date and one time, because then the consequence of not turning up or not being able to make it? So maybe it is just a bit more probing we
Yeah.
need to do.
I think we'll probably do, because I picked up that it was about like making this work better so that people aren't coming at a time when the
Yeah.
person's not available.
May I also flag this up, that obviously the provisions allow for, they mandate if someone is effectively, the police have lodged a file with a view to prosecution, then in those circumstances, it would seem that these provisions kick in for, at the very least, the smaller period of time, the lesser period of time. And so that's going to mean that more people have to provide these samples, as is practically currently the case. If you are, as practically currently the case, if you are released on a summons or with a view to maybe getting a summons later on down the road, people are not required in every single occasion to be coming in to provide these samples, practically speaking. Whereas, as we know, if you mandate for it in this bill, it'll become practice.
Yep.
And so in a sense, to reflect on the need for some provision, there will be a lot of people who will need to provide these samples. if
We
the
need to
bill-
nail this down, I think.
Yeah. So the police might come back and say, well, look, we have a lot of people who we need to get samples from.
Yeah.
How flexible can we be? So, practically speaking, on the ground, this particular provision called the Eye of the Law Society, because it creates practical difficulties you know. And these things have a way of, you know, creating ill feeling where it doesn't need to exist and all this sort of stuff.
It's not broken.
Yeah.
Yeah. Ciara, did you have anything
No,
further?
no, that's fine, thank you.
Okay, Morris?
Thank you very much, Chair. Thanks very much for your presentation. You've answered most of my queries. Anyway, on biometric data, my worry is that even now, before you go out that door, what you know today is out of date. My first computer had a 3-inch floppy drive, then a 5.25 floppy drive, then CD, DVD, and hard drive. And when you're putting a new piece of memory in your machine, you've figured out roughly £5 for every 10 megabytes. You can now buy a hard drive, terabytes, for a lot less than you could buy, say, 100 megabytes years ago. So it does. Technology evolves very quickly, and it's very hard to keep a pace with it. My concern is that we are now heading down the road. First of all, we had number plate recognition. It's only a step down the line to have facial recognition, to have behavioural recognition, to have iris scans, all done remotely. And lampposts, where the wee black boxes are at the minute. So we're going into dangerous territory, and even without a biometric commissioner, there's no comeback. Who deals with the cut-off point? Who deals with when you start deleting? Is it the PSNI, the Policing Board, the ICO, DOJ? There is nowhere for a victim to get his data deleted. And it's getting that bad now that even people who have not been convicted, their data still remains in the system, and it could affect them going for a job in later life if they're young, etc., etc. So I have got grave concerns, and I would be keen to hear how you feel that emerging IT and AI can be future-proofed through this bill.
Well, one of the things about future-proofing AI is that this artificial intelligence is a hell of a lot more intelligent than we are. But that's also why there needs to be some sort of human restriction put in place to legislate for the implications of AI. Well, that seems to be a problem that's being wrangled by every single legislator. I'm going to say even every single dictator on planet Earth at the minute. If you can consider in China, the use of facial recognition is ubiquitous, as it would seem. And so it would seem to me that the minute you legislate for it, you'll be out of date. And so it needs to be constantly reviewed how it is legislatures approach the behaviour of not just the state, if I can widen out beyond this bill, but private companies. If you walk into certain shopping centres in Belfast City Centre, there is a notice on the door to say that they're using facial recognition. And they're not. What effectively they're saying to you is, we put a notice up. If you walk in, you've consented. And that should not be the case. In my respectful submission, it shouldn't be the case that you consent by going and buying a pair of trousers to someone harvesting your data to run through a database to see if you have been a shoplifter in the past. And so we need to reflect. I agree with you, Morris. I think we need to reflect on how it is people have their data obtained, retained in the context of really high velocity transformation of IT. And what I would also say is, Morris, you're quite the fancy guy that you had all these computers going back. My first computer, it took me a while to get my first computer, Morris, but you seem to have been way ahead of the game.
I can remember the internet coming in.
But I hope that sort of answers your question. I think caution is required, but maybe in terms of providing regulation that, again, you're not too prescriptive, that you leave it flexible. Particularly, maybe that's something that the Commissioner can consider either by amending regulations, bringing stuff back to the legislature and saying things need to be done in the annual report, the 12-monthly report that needs to be done. May I also say this? I think very initially anyway, the term restriction on the commissioner seems a bit unrealistic when we consider that the information commissioner's period is 5 years. And yet, what do we have here? Is it 2 years with a maximum of a 2-year renewal, so 4-year max? I think that's what it is. And if one considers that whoever becomes the commissioner has to bed in new policies, new procedures, learning on the job, facing evolving technology, all that type of difficulty, it would seem to me that that period of time might not be enough to get consistent decisions being made, etc. So just reflect on that.
Just one question I'll ask you, and give me a brief answer. It's all right having these checks and balances in place, but you need somebody trained to do the job, and that I think is going to be very difficult.
I agree with you, because it is very difficult, firstly, to stay on top of IT and the evolving technology. And that requires someone to assist the commissioner and, frankly, the chief constable in how it is they go about making the decisions on retention and how they retain, as well as how long they retain information, and to what use that information is put as well. Which I think the commissioner is designed to have powers across the board on those issues. What I would say is I would expect, the Law Society would expect, that the commissioner is properly resourced and has sufficient resources to employ the correct staff at the correct level in order to assist that commissioner to make the decisions that are going to need to be made. So hopefully, Marsh, that's
one thing, just want to have it in my pocket. I lost photographs in that wee card. It says on the card 32 gigabyte. So I put it into a program I have on my computer in the office, and I done a recovery. I got 180 gigabytes of photographs out of a 32 gigabyte card. So is your information ever erased? I don't think it is.
Oh, I suggest the answer to that is we advise clients that it's never erased. When a client has their computers, their phones seized, etc., we simply tell them, but do not work in your police interview on the basis that you deleted material from your device. You work on the basis that it'll be recovered. Yep.
Right.
Right.
Just 1 second. I'm Kieran, I'll bring you back in.
Yeah.
Also, I'm conscious of time because it's now 3:10 and we've still many other sections to get through, so everybody needs to be a bit more circumspect to think about Q&As. Right. Joe, just by way of reassurance, the initial appointment may not exceed 4 years and the commissioner may not be appointed for more than 2 terms. So the maximum length of appointment permitted will be 8 years.
8 years, thank you for that,
Although it's still
correction.
presumably less than the information commissioner. Ciara, you come back in quickly and then I'm moving
Just
on.
quickly, and it's just in relation to the commissioner's role and likewise the chief constable's role regarding the review of retention. You kind of made it quite clear there is, I'm just thinking for the practicalities for yourselves as solicitors and stuff, the need for clear guidance, set out clearly what their roles is and their responsibilities. So I'm just conscious, you believe that's required. What's the impact if it's not for your role?
Well,
Supporting individuals?
Yeah, well, that's a good question. I hadn't reflected on that, Ciara, but what I would say is that obviously this is going to bring in an additional aspect upon which we have to advise our clients. When a client is interviewed by police, these rules kick in. And whereas it might not necessarily have always been that way. And when we say they kick in, they can kick in for the rest of their natural life. So not having clear guidance, published clear guidance, that we know the Chief Con is going to work within, and that we can advise about. And also it needs to be, because this is a fairly impenetrable piece of legislation on this issue, so it needs to be published in a way that the public can clearly understand it as well. Because people who would never believe that their information will be captured for 5 years are going to be affected by this. And never mind 75 years. And I actually checked, and so the life expectancy of someone born in Northern Ireland between 2021 and 2023, for males it's 78.8 years. For females it's 82.5 years. And when one considers that these are broken down to 75, 50 and 25, with no ability for P to instigate a review, that is significant. So if we have a 10-year-old convicted of a serious offence, their data can be retained until they're 85. And with an application, by the way, for an extension as well, if needed. And that concerns the Law Society. Now, we know that there's the provision for 5 yearly reviews by the Chief Con in the legislation. But that, again, that's the Chief Constable instigating it.
Yeah.
And yes, they have to put the person on notice,
Yep.
but it still creates real concerns about civil liberties.
Although, Jimmy Bolger case,
Yeah.
it's always in my mind. Right, I'm really conscious of time here, so everybody needs to try and be as succinct as possible. Everybody. Right, Justin? Go, Justin. You're up. Is it the
Okay, got you, sure, thanks. Folks, listen, thank you very much for your presentation, and listen, I hope your colleague is okay. Fascinating realm of discussion. We could talk about this all day long. I am concerned massively around the whole digital data retention piece. And it's very important that we are really interrogating this from a criminal justice perspective, but I'm really concerned that it's a different rule for the commercial world and what your perspective is on that. So in terms of our web history, our digital data, our location services, all of that has been used by the commercial world, by social media companies, by Google to mine our data to make a lot of money. And we do not know where our data is going. In the criminal justice system, there's more responsibility being brought to bear, and through the work of yourselves. How do you juxtapose those two realities, and what's your thoughts around that?
Justin, can you bring it back to the bill? How does your question relate to the bill?
Biometrics. What is biometrics? What qualifies as biometrics? And is that all about your digital data, your digital footprint? Be that your location services, be that your web history, be that the digital data stored in your phone, which you already alluded to, and how does that then managed in a more societal manner, cross society, across sectors?
Well, I think actually, Justin, I think my previous answer on that point sort of set out where the Law Society feel this bill should go. There are already clearly issues not in the bill that one could positively argue without fear of being corrected that are biometric information, but leaving the regulations maybe in place as well to help evolve what's regulated by way of, because inevitably the police will be looking to capture all sorts of information going forward that we can't even think of today.
Fascinating realm, folks. I think we could talk about it all day. So thanks, Chair. Thanks very much, guys.
Okay, thank you, Justin. 1, 2, 3, 4. I've got 5 questions, but they're all very straightforward. Do you consider that the timeframes proposed are proportionate?
No. In terms of the lifespan of a human being, they're capturing an entire lifespan of a human being. The age of criminal responsibility, I know there's another piece of work being done on that,
Yep.
but the age of criminal responsibility is 10. And this envisages people, with, I repeat it, without being able to instigate a challenge themselves or review themselves. Let's not even use the word challenge, just a review of the need to hold the data until they're 85, with the possibility of extensions. And therefore, and I know there are reviews the Chief Con can instigate every 5 years or so, and I think the same provisions are in place in Scotland. But a
Yes, you're
person,
concerned about the individual's
Yeah,
right to
yeah.
review.
that's right.
I'm concerned about the PACE codes, and obviously these are going to have significant implications for the PACE codes. There's a specific issue for me that I'm interested in around peaceful protest, which appears to be in the same category as affray, riotous behaviour, and so on. And so in that circumstance, a person's DNA could be retained. You could attend a peaceful protest, a vigil, some such as we've seen at Sarah Everard, and your DNA could be retained for 75 years. In those circumstances, should peaceful protest be included in the same public order section for 75 years, in your view?
Well, firstly, it's a fundamental right. But long before the Human Rights Act, we had the right to peaceful protest. It was one of, when I was at university, called our civil liberties. And that remains the same. And the difficulty for this jurisdiction is people exercise that right probably more here than they do anywhere else in these islands. Mm-hmm. And that's actually a positive thing. It's not a negative thing. And people should be able to protest should they have an issue and go and protest outside, the NIO offices, which we see routinely in Belfast all the time. Or should they want to protest, for example, we've recently seen acquittals in the court in Belfast, in the Belfast Crown Court, where people were out walking with others, and in truth, given that we live in a jurisdiction where people exercise the right to go out and publicly protest and do so peacefully, we should really be very careful about putting it in a category that would end up with your data being retained for the rest of your life.
That's my concern. The whole unlawful assembly issue is not the same as affray and riotous behaviour, and yet it's in the same category with the same implications.
I think it's disproportionate. I would agree with that.
Is there anything else within the PACE codes, Joe, and proportionality with retention periods that causes the Law Society concern?
Nothing that comes off the top of my head, and having read the information that we gathered in order to put our presentation together. But, sort of off plan, I'm more than happy to have a look at that. If there's any specific concerns, and come back in writing to the
That'll be helpful,
committee.
just so that we understand in terms of how this is going to impact on the PACE codes and whether or not, because the Human Rights Commission has been very concerned, as have a number of other stakeholders, that the retention periods be proportionate.
Yes.
And look, we're in a free society. This is not China or North Korea. So, we're all trying to find the right balance too. So it would be helpful to have that. Another issue that has arisen has been the retention periods that relate to disposals, fines, notices, cautions. We are not clear under which of those and what types of offences that would result in any of those would result in your DNA being taken. Could you give us a practical example of those, please, so that we would know?
Frankly,
Yes.
I was surprised to see that where a prosecutor does not bring a case to court, that would instigate the retention of data. If it's a fine, the suggestion is that that's actually quite a non-serious offence. It hasn't needed to be brought before the court to mark its seriousness. Mm-hmm. And these types of rules that are considered can often militate against someone taking a fine in those circumstances. And now the difficulty in advising anybody in those circumstances is that it seems that even if they fought the case and won it, their data is still retained for a period of time under this legislation. Mm-hmm. And so therefore, it seems to me that what's been baked into this legislation is the default that if you are reported for an offence, your data will be retained for a period of time.
Yep.
So the only way that it's conceived that it won't be is if you're unlawfully arrested or if it's mistaken identity. People can be innocent, totally innocent, for other reasons. And I know we're pushed for time, but if I suggest this, there have been many occasions when people have been prosecuted and evidence withheld by a complainant that would show that the defendant was innocent, entirely innocent, or withheld by the investigators. CCTV placing someone at a totally different place. They could not have committed the offence. They could not have had the opportunity to commit the offence. And therefore, this legislation conceives of that person's data being retained despite them being completely innocent. So that's also, when you raise that question, it raises in my mind that concern.
That's the 3-year issue, but
Yeah.
but along the lines of this retention period, we haven't been able to establish what are the types of disposals, fines, notices, cautions, where your DNA would be taken, what types of offences?
Well, I would imagine, and you can sort of come in here if you think I'm wrong, but maybe I'm just one of those sorts of lawyers whose clients never get these simple outcomes. But I think that minor offences, we're talking about public order offences. If you look now at the list in the Magistrates Court in Belfast, where it was in the old days populated by assaults on police, disorderly behaviour, resisting police, all that sort of stuff, that has fallen a way off. I'm sure you have the statistics on it, massively, because of these community resolution notices and what do they call the sort of
Diversions
and things like that the police can utilise to stop the courts being populated with all these types of what you might call low level but visible offences that need to be dealt with. They are the types of offences that are diverted away from the court in order to save money and save court time. And that seems to be working very well.
Is your DNA taken for those?
But
Or
this
your
envisages
photographs or
no
fingerprints?
No. I have never had a client who was treated in that way, by stopped in the street by police, guldering, getting on, being disruptive. And I've never had a client in those circumstances then called back in to say, no, now we need your DNA, now we need your fingerprints, now we need your photograph. Never. Since that all was commenced, I've never had that. So I hope that maybe explains the point, but now this provides for that.
It is one to be cautious about, because in the courts you can frequently obtain a fine for a driving offence, but the courts have a complicated enough crossover in that the criminal courts sometimes deal with civil matters. So somebody who's up for no TV licence could go into the magistrate's court and come out with a fine. So I think that is worthy of further investigation.
Yeah, I think
in
that's
terms
something
of
then that we'll need to look at and see what the drill is with that. Just a couple of things then that remain for me. You had cited about, I suppose, a personally instigated request for review, and you had suggested maybe after a certain time period.
Yes.
But do you also envisage in those circumstances that there would be a limited number of requests in a time period to avoid vexatious and repeated requests?
Well, that's actually a good point. When I was considering this, I thought about that. I thought, well, how often can someone come asking for their fingerprints or their DNA to be removed off the database? And so, practically speaking, it's a good point. Police would be inundated. If you think about the Freedom of Information Act and how initially there was an explosion of applications and steps had to be taken to come back from the good intentions of the Freedom of Information Act. Yes, I would agree with the basis of the question, which is that there would need to be time rules about how often you can come back and in what time period, unless there were exceptional reasons. So there might turn out to be exceptional reasons in an intervening period that you could come back. But yes, I agree. Just the practical part of my brain would suggest that otherwise, I would imagine the Chief Con, and there would need to be an appeals process, I would also imagine as well. So you'd have the District Judges Court populated with all these applications that would become unwieldy.
So last question from me then before we move on to other subjects. For us it's page 25 on your paper, Joan Owen, it's the power to extend the retention period. In that first paragraph under that section, you have cited it's important that individuals can access legal representation for these applications through legal aid under a criminal certificate to ensure access to justice. Can I check? Obviously, there are circumstances where legal aid is means tested, and there are circumstances where you get legal aid regardless. I think particularly domestic abuse and stuff.
And PACE.
Yeah, and PACE. So, what do you envisage for this? Do you envisage legal aid for everybody regardless, or a means test?
No, when the Law
it be
Society included criminal legal aid in it, they conceived of applying the Widgery criteria, which we apply in applications for criminal legal aid, to a district judge. So the district judge who would be hearing the application would make the decision as to whether the person was entitled to legal representation paid for through legal aid. And applying the Widgery criteria is important because the Widgery criteria includes things like implications for your ability to work, implications for your standing in society in terms of your reputation. And it also allows for things like if you need an interpreter, for example. So it won't just be all us English-speaking people who will be making these applications. There will be applications made by people for whom English is not their first language. And so the Widgery criteria seem to capture that. In addition to that, there's always a means test involved in that statement of means. It's called the statement of means application for a reason. And so the judge can apply the statement of means in terms of their income, etc., and the resources to the principles, with the Widgery principles that are applied, and make a judicial decision as to whether or not a person should receive that type of assistance. It seems sensible as well because this emanates from the criminal justice system as well, and it's not an accident that it's going before a district judge who deals with criminal matters. So I think all of that, that's why we've made that suggestion.
Okay, that's fair enough, thank you. Anybody got anything else, or can we move on? Right, we're going to move on then to children's bail and custody. Danny?
Thank you, Chair, and thank you. See, in regard to the police being afforded broader powers to detain children in the courts, does clauses 4 and 5 address this, or is there more clarity?
I have found the preparation for today and listening to everyone today very strange, in that you're so used to dealing with what's happening on the ground as a solicitor, and you get lost in that world almost, and you're concerned about your clients. And solicitors act for victims, for witnesses, for suspects, defendants. So we see everyone nearly involved in the system and try and help them and help the system. But today I've had a rewind in my life to when I studied politics or studied constitutional law, because it's brought me back to why it's very important to have the separation of powers and to look at things before they come in, which is obviously an important job of the committee and many here. But in my own personal view, I find what happens in reality so crucial. But what we need to do is protect our armoury, and a person's, or in these circumstances a child's armoury, to protect their position. And this is significant, because if something happens where somebody's rights aren't protected, and somebody is wrongly detained in terms of natural justice or just common sense, you then need to look back at the law. And if we're going to take a case to court on a judicial review or a habeas corpus or whatever, or to a bail application in front of a judge, or representations in front of a custody sergeant, we need the law to be as protective to the child as possible. So without doubt, anything in terms of new legislation, it has to be as strong in terms of protecting the child's rights. But in reality, and this is where it becomes more depressing, whatever the legislation says, the situation on the ground is depressing, particularly children who don't have a family member to go back home to, and particularly looked after children. So, you know, that's the reality, of course, but of course that shouldn't distract from trying to make the best effort at this legislation, and the stronger the protections are for children, that's crucial. I didn't realise actually, but one of the years we got the figures on, it was 5% of people arrested were children. And I remember looking at that before, and as Joe indicated earlier, there's so many diversions, so that's not even the full extent of children becoming involved in the criminal justice system. But one of my saddest days in the police station or in the youth court is when there is a child with no address, and they have to go either to Woodlands for the night before they appear in court, or even worse than that, whenever they appear in court and they're granted bail, and they still go to Woodlands because social services won't provide an address or struggle to find an address. So there could, in my mind, there could never be enough protections for a child in this situation, because children should not be detained unless it's a last resort.
Do you think there's enough in what's being proposed in this bill, particularly around the broader powers that just highlighted for the police around that? Is it covered in 4 and 5?
In theory, yes, but I think it should be supplemented as best as possible with resourcing. And it's a bit like when it's amazing how many children don't ask for a solicitor in the police station, and that's because it's the right of the detained person. But in practice, police aren't really going to encourage people to have a legal representative.
Is the appropriate adult not?
Well, the appropriate adult, again, that's different if it's a looked after child, or there's an appropriate adult scheme, which is different to social services. Sometimes the appropriate adult role will be a family member. It could be an appropriate adult from the scheme, or it could be a social worker. Some of the social workers can be more proactive about encouraging the child to say, do you not think you should get a solicitor? But that's not, there's no continuity in that or certainty.
Sorry, when I'm just trying to work this through, every person under 18 who's taken in for a police interview should have an appropriate adult, is that right?
If they're going to be interviewed or processed or charged, yes, they will have an appropriate adult.
But not all of those appropriate adults suggest to them that they should have legal representation.
I would
inconsistent.
Sadly say I don't think it's even a majority of appropriate adults would suggest that.
Sorry, Danny, I just wanted to understand what was...
It's, and in terms of there was a youth justice agency had a bail support scheme whenever something went to court. It's still there. It's not focused on as much as it once was, and maybe it has become part of the system that's accepted, that's one of their roles. But there was very much a flagged effort at that to avoid people being detained in Woodlands, and I'm not sure if anything could be fortified in that regard. There is the law there that social services have to. There's cases on that, that social services have to find a place for a child if there's no alternative. But it does happen. The figures are there as well. I'm sure you've had an opportunity to see that. How many people go to Woodlands pre-court, post-court, and the figures are minimal for people children who end up sentenced. It's not really sentenced people often that end up in Woodlands.
Yeah,
so I would like to see but again, I think sadly your hands will be tied in amount, because it will then really flow through to the system. Can social services, can the police, can solicitors do their best then to make sure that we build on what's in the legislation?
I suppose that goes on to my next point then, because you highlighted that the revolving door effect and the complexities of risk behaviour of young people, and then obviously children with additional needs, and the supporting role that the solicitors, an important role that they do in that. Is there anything within the bill that can strengthen that role for solicitors, and I suppose then mitigate against the revolving door effect?
There's a significant focus, and has been for a period of time, on restorative justice, diversion, desistance, and it's even on a positive note seems to be moving towards the adult criminal justice system, that there's efforts there to try and learn from some of the positives with children. But it's difficult to see what could be supplemented, apart from perhaps taking it to the point about the codes of practice, where those are important on the ground. And again, I think we've made the point that that's where the real impact will be, and that's a vehicle to ensure a positive impact. So there should be certainly amendments to the codes of practice in tandem with new legislation. I think that's where everyone could help the most.
Just one more question, and it's a bit of a biggie, and it's not in this bill, but it would fit into the bill, and that would be the criminal age of responsibility. And I know my oldest boy's 10, and if his mummy doesn't lay everything out for him, he wouldn't get out the door. Never mind holding him to account for.
My wife would
for
say
anything.
that about me.
Well, I suppose you say I get the same as well. But it's just your view on that, and suppose then that we've heard different evidence around 14 and 16 as well.
Yeah, well, the Law Society point settled in terms of their submission at 14 or older. And yes, you know, I know when we were researching that submission, there were very dramatic viewpoints either way. And I went to a care home or children's home relatively recently for a young boy who was a matter of days beyond his 10th birthday. And I found that very sad. And I begged the police officer, I said, look, you know, really, you know, whatever has happened, we have to do an interview, I understand. Not entirely sure I agree with you that we needed an interview, but at least it wasn't in a police station, and I was able to go there to make it a little more comfortable. But 10, 14, 16, those are difficult debates. And I know the point was made earlier by the Chair about horrific cases that stand out. So it is very much a balancing act, and I know the official Law Society position is 14 and some consideration then for if there are other offences maybe alleged in a zone between 10 and 14. That's a challenging circle to square for any.
No, I know it is. It's a political discussion, well, but I suppose just with having this bill in front of us, it would be, in my view, maybe possibly a missed opportunity. I don't know if you would share that, not to get it in.
It's what order you put, and the sooner that's looked at, the better, without doubt. I think the Law Society would welcome that nettle being grasped as soon as possible. But at least in the bill, there are some
I think
age distinctions.
The bill framework to me looks like it's being established at 14. But there's no political agreement on it in the executive, and likely not in here either. But I think we can all see the pros and cons of each side of it. That's you done.
Thank you.
Deirdre, you want in there?
There's only a point of clarity on what you said around, because there's nearly like I suppose a belief that children or anybody in the system has access to legal representation. But are you saying that's not explained when a child's in a custody environment in the majority of cases? So there's no kind of agreed text that is read out to all children, no matter who they are, in terms of you have a right to legal representation?
Well, there's a tick box exercise effectively, which everyone who's arrested or even subject to a voluntary interview, there are lesser safeguards there, but everyone is given the same suggested rights. But there have been a number of meetings over the years, and I've always tried to argue that there should be something more for children, that there should be more active, proactive encouragement.
But it's understood as such as well.
Absolutely,
Yeah.
and in fairness, I think there has been a change in that I have often, not only appropriate adults, but more surprisingly, had police officers and custody sergeants in contact saying, look, this person was wavering. And particularly in the case of a child, they would say, look, we would really like to see the child with a solicitor. And that has been a very healthy development. And even, I know it's difficult to talk about cases, but even recently, I've noticed a change when I had a conversation with a custody sergeant. And normally there was a debate, if there's no address in terms of bail, there was a defeatist attitude I often found with the police, which was, well, what else can we do? But recently I had a sergeant who said, do you know what, I'm actually tempted to release this child without charge on report to the Public Prosecution Service for a summons or a diversion or a letter of no prosecution, and I'm then going to keep the child in the police station as a place of safety until social services come here and find them somewhere appropriate. And I was so impressed by that. You know, I thought that was a very healthy balance to try and improve the situation for the child.
I think there may be circumstances where we can flag this up with our policing board colleagues to say, look, can you take action on this to ensure that whenever a child is in this I mean, I think it's something we don't have a remit over the police beyond their budget. But and that's what the policing board is for, but we've all got colleagues on that board. And I think it may be a means that we can, because I think the custody sergeants now, it seems to me, have a bit more nous about how to deal with practical aspects and to do the right thing in human terms.
And may I say this? I received correspondence this week, someone who was subject to investigation by trading standards, and they wrote to that person. I thought it was very good policy. They wrote and said to that person, you're entitled to bring a solicitor, and obviously they'll be interviewed under caution, as everybody tends to be, but bringing a solicitor with you does not imply that you are guilty. And maybe for young minds that asking for a solicitor might imply that they're guilty, and that therefore a reluctance, and also because of their child who's a cared for child, whatever, they may have issues with adults, they may have certain things going on in their background in terms of vulnerabilities in their life that might make them suspicious of strange adults. And I think maybe if the police could insert something or something could be inserted to actively suggest to a child that it's in their best interest and it doesn't imply they're guilty. If trading standards can do that for someone, I think the police could do it.
I think that is certainly something we'll take up with colleagues on the board. Kira, you wanted in briefly?
It's just on bail support that's currently offered to children. You've also noted that it's critically important that bail support should be offered to the adults who are going to be looking after the children. Can you just throw some light on that and what currently exists, of any support?
Well, we were trying to be open on that in terms of carers and parents and other siblings even, who often have to step in. It's, again, that's more a court stage, I find, because whenever a child's in the police station, there will be the appropriate adult in the mix. There'll be maybe other family members ringing in, or if they're not the appropriate adult. But it's the Youth Justice Agency really who try and tie it all together. If the solicitor can't, and particularly with children, the solicitor will try and put in place an infrastructure support network, an easy soft landing as best as possible from an arrest situation. So I don't think, again, that's probably, I think the police have welfare training and all of that in place, and they do try their best in my experience, but parents and carers are pulled in more by the Youth Justice Agency at the court stage. The bail supports are limited for the pre-court stage at the police station.
Okay. Anybody else on children bail in custody? I have two issues. We had previously raised the issue around seeking clarification as to whether or not refusal of bail on the grounds of public order, whether it referred to the child's engagement in public order or whether it was about public order in the community who didn't want child released on bail. We've now determined it's both. Could I have your views on that presumably from the defence perspective? Because it seems to me if you have a right to bail, you have a right to bail, and it's not for the mob to determine. But that's just my view.
There is definitely a slightly separate practical approach taken, I think, to public order situations, depending on the temperature within the community. And that can be of different natures. And over the last number of years, there have been situations where you could see the police, including custody sergeants, taking a harder line with children, and particularly at that stage of disposal where you would normally have encountered this should be referred to the Youth Justice Agency. Some of the public order stuff would rarely go to the youth engagement officer within the police. It would more go via the Public Prosecution Service, the Youth Justice Agency. But certainly there would be a more pro-charge approach even to children if there's a public order element. And again, that's where you would see particularly a geographic restriction, don't go to a certain area, or don't associate with certain individuals, and even curfews, depending on what the times were. And again, it's part of the debate around the bill. The custody sergeant has slightly less powers than a court would in terms of bail powers. And again, with children, it's not as significant, perhaps, because they can't impose an electronic tag, for example, with a curfew. So there is... The theory will be the same, but in practice there absolutely is a harder line taken with children and others around public order matters, but it does depend on the context, sometimes the time of year, and different other variants.
And we are conscious that there should be children in custody whenever they've been granted bail, but sometimes there's no place for them, and we are aware of the issues with social services trying to find placements and stuff, and we also have been made aware of the fact that more often than not, simple things when children are placed somewhere result in a breach of bail, and the police are called that wouldn't necessarily happen if they were at home. So we get all that. But Owen, your point takes me to my next question, which is around conditions. The bill kind of implies that there should be no conditions except in very certain circumstances. What's the Law Society's view on that?
The way that you would always balance that is in terms of reasonableness, proportionality, and if it came down to a debate between going to Woodlands or going out on bail, most children would accept that they're better going out on bail, even if they think the bail terms are unreasonable or disproportionate. So there's a wider issue around bail reform, and that's being looked at and trying to choreograph all of the different powers that are there. But I think that there was a debate in England about bail terms and released under investigation and different things. Mm-hmm. It's with children, you always should avoid the arrest in the first place. It should, as frequently as possible, be the voluntary interview, the PACE 10 approach, or even better, a notebook interview. Mm-hmm. But if it goes into an arrest situation, the less conditions there are for children, the better. I have encountered children who, it's a bit like the ASBO debate. Sometimes if you put in place bail terms or put in place an ASBO, it encourages the revolving door involvement with the criminal justice system. Mm-hmm. And I have many children who I've acted for who never ended up convicted of something, but they got themselves arrested 5, 6, 7, 10 times maybe for breaches of bail. But again, it comes back to, as long as there's an opportunity for representations to be made by a solicitor, opportunity to vary those bail terms if there are developments, I think it's all about reasonableness and proportionality. There are some circumstances where maybe there should be no bail except, you have to go to a court appearance at some stage. And in the youth justice system, you'd invariably see a child signing a bail for £50, whereas in the adult courts it would be £250 or £500. But there are certainly situations where no bail terms would work, no substantive bail terms, but there are cases where certainly bail terms will allow somebody to maintain their liberty. So I accept that. I don't think that you can take away bail terms for children.
Well, this is what I'm trying to. So, your point at the start, whenever you start to speak, actually highlighted everything for me, because you're starting from the practical position and trying to work back. Mm-hmm. What I said before you come in was, I think as a committee, we need to be starting at this position and working forward to understand, okay, this is what the text is, but how does this work in practice? And that's what I'm trying to understand. It seems to me there will, without question, be occasion on which bail conditions are helpful and necessary, and yet you must not impose bail conditions. So I'm trying to strike the balance from practitioners. Is it fine to say no conditions, or should there be a degree of flexibility beyond the child's not going to surrender to custody?
Well, I think again that's where the codes of practice perhaps come in an amount, and there has to be the necessity of the arrest, obviously, as part of this debate. But then any release on bail should be based on necessity for those bail terms, and there will always be cases that will be on a I suppose a thin line as to whether they're going to be charged and detained or whether released. So I think there certainly should be something
Yeah,
there
and
to
look,
allow
it's-
for bail terms.
I'm asking you guys these questions because it's very seldom that we have in front of us people who are at the cold face of this. And when we think about this and we're talking about MACR and we're thinking, oh, 10-year-olds, but 17-year-olds,
That's right.
you know, so it's not straightforward. And I want this committee and I want to fully understand, okay, well, what are the implications of all of this for that massive spectrum between 10 and the cusp of 18?
That's right.
You know, so that we actually understand, what does this mean? What does it look like? What are the good sides and the bad sides?
And there may be a case for a graduated approach in terms of the age of the child. And look, we all see the news every summer when kids aren't at school and they end up at flashpoints and interfaces, and we end up with public order issues. And anybody who grew up in a working class area in Belfast in the 70s and 80s knows how easy it is for a child to end up even on the periphery of an incident like that. Nowadays, they're captured by PSNI CCTV. 2 days later, they get a knock on the door, and they were present somewhere. If that's a 10, 11, 12, 13, 14-year-old child, and then bail conditions are imposed in those circumstances of whatever nature, it ignores the fact that that's a very immature mind who has to rely on guidance from parents. And in all of this, there is no responsibility within this bill placed on the parents. And not that I necessarily want that to be the case, because a lot of parents are struggling themselves. But if a child's coming from a background where there is social deprivation, lack of opportunity, there's the excitement of public order over the summer on their doorstep, and having come, if I can say, from a personal capacity from that scenario as a child, I empathise very much with that child. I understand why that child feels that there's nothing particularly wrong with what they're doing, because they're 10, they're 11, they're 12, there's something exciting happening at their front door. And so the law, I think, needs to reflect on the immaturity of a child and whether or not a child needs, for example, to have to suddenly live somewhere else, because a lot of these children, it's happening at their street. And custody sergeants might say, well, look, they can't go back there because that's a flashpoint. But they might not have an alternative address. Or, well, they can't go back there for their own safety because their neighbours aren't happy, etc., etc. And these considerations are difficult. But when you're trying to tread this path through legislation, to go back to the thing that Owen said right at the start, if there is a doubt in your mind about the need for it, then there isn't the necessity for it. And you've maybe got to legislate in favour of the child. So I understand that that may not apply to 16, 17-year-olds who may, due to their age, present as more of a risk to public order and more of a risk to police officers who are taking the brunt often of the public order, etc. But a graduated approach might be something worth considering. I'm not suggesting what that graduated approach is because it's too difficult a conversation for today. Yep. But it might be something that people get their heads together on and think about.
Yeah, maybe. Well, that's helpful. Thank you. Right. Anybody else anything on that section? No? Right. Live links? Anybody got anything? Nope.
It's just one thing,
Okay.
you had mentioned just regarding the quality of the internet connection within the custody suites. Can you just throw light on that? What's the scale of that at the minute? Or?
That has been very frustrating because obviously everybody had to react so dramatically to COVID on so many fronts. And what was admirable, I thought, other areas in the justice system had to effectively pause or defer everything, but the criminal justice system had to still deal with the people who were in the prisons, the people who were still being arrested, albeit numbers were down at the initial stages, but the police interviews were still taking place when somebody was interviewed, and the courts, even in the criminal justice system, had to get back into action very quickly. And the technology that was embraced by the courts was swift, ultimately after a number of weeks of disruption. But in the police station, that was very frustrating, to try and still get access to a detained person, to advise them and keep the process moving. And in fairness, the police and the Law Society had many meetings where we tried to work out more ways of sharing information remotely via secure email, and there were certain improvements put in place for that. And there's handsets in the police stations, in the custody suites, and we would have been able to access our clients for advice, not always in a confidential setting, which had its drawbacks obviously, but we worked with everyone as best we could. But in terms of then, when you were attending an interview remotely, you were reliant on an iPad at the police station, because strangely in the police interviews there were screens in quite a lot of the interview rooms, but those would be more for showing of CCTV to a suspect during an interview, or even a lot of the police interview rooms are recorded so other officers can watch what's going on in the interview. But we were not permitted access to those systems to try and hardwire, if that's any way correct technically, into our clients or interviews. So very quickly everyone had to try and get iPads into the police stations, but then unfortunately the way the stations were built, it was very hard to get a signal. So that has endured despite more and more meetings when we have asked the police to adapt their practices to allow for, more remote access in terms of advice, be it with the client pre-interview, post-interview, or during the interview, and that has been challenging. So that's why we put a focus on that.
I actually had a meeting on Tuesday where I raised a similar point, because I understand that interviews are being conducted through Skype. Remote interviews being conducted through Skype, which no longer exists. And so the police have now moved to FaceTime, which is all well and good if you're an Apple user. But for those who are trying to dial in on Android, there is no mechanism. Therefore, those practitioners have to go in person. Now, sometimes the offence can be sufficiently grave that you've got to go in person anyway. But people should not be losing their right to have legal representation purely because that practitioner doesn't use Apple. So I think I've had a conversation with the police about this to say you need to be looking at this because people need access to their lawyers, and you've got all of the technology there. This shouldn't be an Apple FaceTime issue. So
It's been very strange to deal with it over the last number of years because everyone had a pivot, and everyone has tried to take the lessons from COVID, particularly the good innovations that were forced on everyone. But that position has been very frustrating, along with some issues with the prison. But in that context, certainly, I think for whatever reasons, the police have been slow to let outsiders have access to their technology.
The other thing is this: if you have a client who is subject to an application for a judicial application for an extension, you cannot, even on your own device, access legislation or case law that you're going to need to argue it. You literally have to get up and leave the police station and go somewhere, print off hard copies, etc., etc. And that is not, it's far from ideal because it delays the person's detention, it delays the judicial decision as well. So it leaves a judge potentially waiting around. And the lack of infrastructure where a solicitor can securely access the internet, in order to access but are nowadays the basics, in order to move or defend an application for an extension, for example. And that doesn't just apply under PACE, it applies under county court extensions under terrorist legislation. So one might say that's even more grave, that a person has no immediate access to the internet in order to prepare their legal submissions to the judge. So there is a strong argument to say that there should be readily available, secure internet access for members of the legal profession in police stations. And given that that infrastructure already is in place in police stations for access to the internet, etc., I would say, not having costed it, not being an expert in the area, but it would not impact heavily on the police budget in order to ensure that that is available in custody suites. And remember, we make these applications for extensions in custody suites as well. So, for example, when Antrim was the Antrim Serious Crime Suite, there is a room in there that doubles as a courtroom with a link to the High Court. So these things are doable and they're just not being done.
Right. I have one more question on live links, which just relates to if somebody is dialing in then to conduct an interview, if the officer is in a different station, does the person who sits with P in the custody suite, in your view, does that also need to be another police officer, or could it be a civilian staff member?
In practice, it will probably be a civilian defence, or I know that the legislation for assaultancies, the CDOs, the civilian defence officers, would I imagine be pulled in to that. Now, there's an issue about blurring lines in that the CDOs are very careful.
This says officer, so I just want to check, to your mind, does it need to be an officer, or would a CDO do?
I think the better position would be if it was a police officer rather than a CDO, because the CDO job is very difficult with detained persons, and if somebody was then associated with the investigation, it also may cause difficulties evidentially. If something was said, is that CDO going to become a witness at court, or are they going to have to give a statement? So albeit that then would surely defeat the purpose of having an officer elsewhere to conduct the interview, albeit maybe they wanted to show some exhibits or something of that nature, or from a different location.
And the CDO is in essence a deputy of the custody sergeant, and the custody sergeant has a number of functions, as we know. Important one being the welfare of the detained person, but in addition to that, they have to be an independent decision maker as well, independent of the investigating team. And when you start to introduce the custody detention officer into what is effectively a policing role, part of the investigation team, which de facto they will be, because they'll be playing the role of the second officer. So at the minute we have two officers sit in police interviews. One officer tends to be a witness to the other officer in many respects, which is why when we get to court we tend not to call both to give evidence. And it would undermine, in my respectful submission to the committee, the important role of the custody staff to have a CDO sitting as part of the investigation.
No, that's fair enough, thank you. Right, let's move on to part 4, which is administration of justice. Ciara?
Clause 28, and you have given us a brief and given your opinion on that. Just in relation to the consequences, if it was to progress, in relation to the role of taxi master here in the north, being out of line with the rest of UK and the 26th, what's the impact? And if you just want to throw light, I suppose, just on the role, and I get the fact that given that enabling access to justice is at an early stage and we don't know what it is, you can't really give that much detail or opinion on what the department is proposing because we don't know. But the impact, if it was to go forward in relation to...
Well, it's back to the point earlier about the separation of powers. At present, you have a judicial figure who is a safeguard for the justice system, but also there's an obvious balance there, which is that's somebody who's independent rather than the legal aid authorities who are funding a case and then assessing a case ultimately. And the taxation debate is obviously a delicate debate for a variety of reasons, but in the solicitor world, recently there's been a new practice where effectively it's been indicated that the break-even rate for a solicitor's office needed to be increased. And solicitors obviously employ a lot of people. Solicitors have offices in local communities and are connected very, very much with those communities via employees, but also their clients, and also obtaining services from people there. So we obviously have significant costs to keep our businesses going, and taxation monitors that and amount with those reviews of the break-even hourly rate. That's not even with a profit in the mix. But in terms of the taxation element of this bill, it seems strange on common sense grounds to do everything in this order. Why would you put a clause that effectively removes legal aid taxation where required going forward without actually looking at the total picture? And recently we have engaged collaboratively, like we do, with the Department of Justice, for example, on High Court bails, because that was one of the elements of taxation reform that was being looked at in a certain order. And the DOJ thought that High Court bails were somewhere they could start to look at reform in this area. And we had a lot of information there about what the average cost was to a case that had gone to taxation. The solicitors had detailed, as they have to do in every case, all of the work that they did, and the department were able to obtain that. There's then an existing composite fee for a High Court bail, which is £180, and we had made representations that that was inadequate for the amount of work we do. And whenever you put that on the table, put all of the work that we did, there then is the opportunity to have a mature debate in a collaborative fashion, which is, well, actually, if 180 isn't correct to reflect the work that's required to help that person, and if the taxation process shows the amount of work that's required, well, then can we work a system that is a new composite fee, perhaps with some exceptional cases, an escape provision for cases that are particularly challenging, where a composite fee is too inflexible? Well, then, in a situation like that, you could see how taxation could come out of the picture. But that, to me, looks like the more common sense approach to it, rather than loading the dice effectively, which is remove taxation from the legal aid cases, and then actually we'll worry about what replaces it down the line. That's a standalone point, obviously, with the benefits of a judicial figure looking at this. It shouldn't be underestimated either. And from dealing with these type of cases, the process is onerous for solicitors. Not only was there historically a rate that wasn't reflective of the cost of running our practice, but also the amount of work we had to do and the processes around taxation. There are certainly areas up for improvement to help everybody and help the system, and I'm sure the Law Society and solicitors will engage with that. But this order, as outlined in the bill, doesn't seem appropriate.
Okay, thank you.
Yeah, anybody else, anything on taxation? Justin?
Thanks, Chair. Who's driving the agenda behind removing the taxing master? To what end?
Certainly wasn't introduced by the Law Society or the solicitors, because one hears many complaints from solicitors about the taxation process and the costs and the delays and the strain on cash flow for a variety of reasons. But it was the Department of Justice who have introduced this, and I'm better not try and answer for them.
Go ahead, Deirdre. Oh, hold on, just let me check. Justin, you finished your view more?
That's fine, Chair, thank you.
Go ahead, Deirdre.
I think a few of us are concerned around this in terms of, I suppose the Minister has said it's around managing public funds, But obviously I'm keen just to understand a wee bit more in terms of the separation of powers, because this appears to me like a power grab almost back into the department. And in terms of that independence or oversight, I mean, obviously public funds have to be managed in the most prudent way. And obviously, you know, addressing the issues of access to justice, which we're all concerned about. But it is that issue, if you could just go into a bit more detail in terms of, from your view, why the separation of power is so critical, and even that work that you talked about earlier in terms of the programme around access to justice, would you still see the outcome of that, that there still needs to be that separation around the role of taxation?
Even in a situation where there was an agreed approach to a new remuneration arrangement, for example, around High Court bails, because that's the one more on the horizon, I personally would like to maintain taxation somewhere in that system, albeit I can see how a new system would work better for everyone if it was more limited than currently we encounter. But and at the meetings with the department, they applaud the solicitors in the taxation process because they have mined that data for whatever reasons which they can answer for. But they always come back to us and say, there was so much information in that documentation about what you did to help your client. And then on the specific point, obviously the taxing master is something that we value because solicitors and have a strange relationship with the legal aid authorities, because everything is very much branded around access to justice. And there's been debates about the rule of law recently, and access to justice is an important part of that. But on the ground, most solicitors would have a view, I imagine, that the legal aid authorities don't always help you ensure an access to justice. And instead of a culture of granting people certificates to help them express their legal rights or protect themselves, that the first point is no. Or what's worse than that is, even when they know it's a yes, how can we put hurdles in place to make that more difficult to get to the yes? And I appreciate the other side of this, which is taxpayers' money is valuable, and any money that is spent by taxpayers, stroke the government, stroke the departments, should be value for money. But in the taxation debate and more generally, solicitors provide unbelievable value for money in what they do under the legal aid systems.
And has that come up, the value for money issue, in the discussions that you are having? Because that has been what's been reflected at times.
In fairness, it has, and there's a common ground on that. You know, we always take the view in our discussions with the department that we need to do a certain amount of work to help that client or protect that client, and we will do that in the most value for money way there is. You know, there's no dispute about that. We're on the same page as the department on that. Where I suppose there's more of a dispute normally is what the end game is at the end of those discussions, because obviously any department or government will try and curtail the spend within reason. But again, the point's made about legal aid is difficult to predict because it's reflective of certain needs in society. It's also reactive to perhaps what the police do in the criminal justice setting or what cases arise. Yeah. So we as a society, and even individual solicitors, I think, are very aware of protecting the legal aid fund, protecting the expenditure. And in our discussions, we have indicated whatever the available funds are, please spend it in the right way to ensure value for money and help us do our job, which has been very difficult over the years. And I think the committee had an opportunity to see the Hook Tangaza report on that front, you know, just how strained solicitors' practices were often.
Well, thank you for that.
I've some stuff on taxation, if that's all right, gents. Yes, what we have gleaned from listening to the department is the problem seems to be a bit more with the bar, and that they as do we, struggle with the transparency around brief fees. And that seems to be an issue, and we've been in conversation with the bar about that. They had highlighted some concerns around equality of arms on the basis that those who were afforded legal aid would be subject to departmental assessment of costs and value for money, and on a case-by-case basis, which is of concern to me in terms of consistency of approach. But there would be inequality of arms for those who then were not afforded legal aid and were financing their case themselves or privately, which in terms of awarding costs, and they had expressed some concern about an inequality of arms in that sense, that people on the legal aid side of the house would be subject to very different assessment because the people who are going privately would still be subject to the taxing master. Do you have views on that?
Well, there already, sadly, is a two-tier justice system out there in any event, because the legal aid system on some fronts is inadequate and has been for quite a long period of time. And this certainly would compound that reality, because if, depending on the parties in an action, there's certainly a further pressure point on the vulnerable if they don't have that protection on a legal aid certificate that is going to be taxed by an independent taxing master, that will perhaps go into the department effectively, because it will be assessed by the legal aid authorities. And of course there is an equality of arms point, no doubt, in this.
Thank you. Just staying with the administration of justice, could I ask you to look at your part for your page 11 of your document? It's for us, it's page 31, and I've two questions on this. The no bill issue there, you raise a potential concern in respect of this clause. It could be when direct transfers come into operation, as issues and questions can usually be raised at the committal stage. Could you just explain for us what that means in layman's terms? And my second question relates to your next point, which is the statutory charges register. I think in a previous submission to us you had highlighted some concern over where property is jointly owned, and the implications of what's in here for that. Could I ask you to just maybe elaborate on both of those points, please?
In the direct transfer area, that is similar to some of the other discussions today in terms of trying to future-proof anything that's happening, because there already has been an amount of committal reform, and then there's a suggestion that there'll be a dramatic enough move to direct transfer, and the committal reform has taken away the ability to call witnesses at the stage where a case is transferred from the Magistrates' Court to the Crown Court, but a suspect or defendant at that stage can make representations at least, and sometimes those representations are very important for the first stage of a Crown Court case, which could be the no bill application, which is even before the arraignment of guilty or not guilty takes place. So we were just anxious to make sure that if there was a gap being filled, that there were still rights for a defendant, that they weren't going to be prejudiced by a new process that we didn't know the dynamics of. And again, that's perhaps difficult to speculate over now, because I know the police and the Public Prosecution Service are desperately trying to get ready for direct transfer in case there's more pressure on cases moving more quickly, more efficiently. But we didn't want this caught up in that new era in a detrimental
Sure, I fully
way.
got this, Owen. Could I ask you to just go over it? Could you just talk me through the process?
In the current process, or
Well,
I suppose we're speculating them out because of the direct transfer.
If you talk me through what's proposed, and then just how it would work in practice and what you're worried about.
Yeah, it's
Just sort of, I'm not picking it up fully yet.
At the moment at Crown Court stage,
Yeah.
if you lodge a no bill application, one of the first questions that will be asked, did you challenge this at the committal? Now, obviously, if it goes into direct transfer, perhaps there won't be an issue because you won't have had that opportunity. But we just wanted that factored in to any change in relation to the area of no bill. There's other cases that have arisen about no bills more recently as well that have had significant implications. But we just wanted to flag it because we were worried about the full picture
Process
about
point being
direct
lost.
transfer not
Well,
being
the benefit
clear.
too of committal proceedings was highlighted in that recent unlawful assembly case, where one of the participants successfully challenged the charges and was not returned for trial. And if you think about that, that's one less person in the dock, one less team of lawyers in the Crown Court, arguing against what was an inherently weak case. And so therefore, whilst most cases are properly presented by the prosecution and are returned for trial, the right of an accused person to have their papers scrutinised, the case scrutinised, legal representations made, and the prosecution case challenged at the magistrates' court is important because it prevents people ending up in the Crown Court system who really shouldn't be there. And our Crown Court is already, the backlog is enormous. It's inundated with cases. We don't have enough judges. We don't have enough courtrooms. So where you can whittle cases out of the Crown Courts, you save money, you save time, you save resources, other types of resources. And so instead of having a 3-defendant case, you can end up with a 2-defendant case. And a 2-defendant case will run more quickly than a 3-defendant case. It's as simple as that. So there are very good reasons for maintaining the committal process because it maintains a level of judicial scrutiny on the process. And at the end of the day, maintaining judicial scrutiny, whether it's first appearance, are the police correct in charging someone overnight? Or is there evidence for those charges? But judicial scrutiny on issues about opposing bail, all the way through the process, having that maintained judicial scrutiny is actually one of the priceless aspects of our system.
But that's already, I mean, the issue of committal reform has been kind of going on for a long time.
It has.
The ship has somewhat sailed, has it, Joe?
Well, the direct transfer takes away an opportunity for argument on the papers that might, you might say, is something that is one of the civil liberties in the system that is worth maintaining.
I mean, presumably this was done, presumably the committal reform was undertaken in order to save money and time.
Yes,
That was part of the rationale for it, and yet what you're saying is actually it was a fundamental component to save money and time because people could have been pulled out of the system.
Well, that's right, and people might say, well, look, how much money are you saving? Well, that's because committal as a thing has been whittled away over the course of my career. And so preliminary investigations or mixed committals where you had a mixture of evidence and papers examined, that has all been sort of whittled away over the years. And if we go back to basics, in my respectful submission to the committee, no one should be before the Crown Court having to make a no bill application.
Okay.
If it's inherently weak, why are we making no bill applications? So that's, I think, something that's maybe oversimplistic, but I think it's worth considering.
Although this no bill thing is very specific to the death of a child or vulnerable adult.
Yes, that's right. That's right. Well, actually, that aspect of it, I think, well, I think the Law Society have seen the merit in the proposal on that.
And then just the statutory charges issue
I think
at page 11 of your submission.
Yes, I think, again, that was fear of the dark, an amount, because obviously there will be guidance issued in due course as to how that would be managed by the legal aid authorities, and it was just to ensure that if there had been issues, perhaps even in a family case where there's joint property, that there was some ability to reflect that or protect other individuals who maybe hadn't received the legal aid certificate.
Thank you. Anybody else have anything on part 4 of the bill? No? Right, can we move then quickly to the amendments? Gents, you've been very gracious with your time, and actually your answers are really helpful, because this takes us into the practical arena that we don't get very often. Okay. Anybody got anything on serious organised crime? Restorative justice? Rehabilitation of offenders? Access NI filtering? No. Repeal of vagrancy?
Yeah,
Connie?
I did, yeah. Thank you. I really appreciate your comments and in your paper around the repeal of vagrancy. It's not something we've really heard as much of at this committee than other issues, and it's something I'm really interested in. And I just kind of wanted your views just to hear a bit more. I think you'd said in your paper that it's your view that the current criminal justice system framework already provides sufficient mechanisms to address public order concerns without resorting to vagrancy laws. I just wondered if you could maybe tell us what you think is appropriate and would work well once, if these laws, are repealed.
Well, firstly, a soft touch. A soft touch by police in terms of the specific vagrancy offences that are on the books and are utilised by police. When people are living on the street, they are inherently vulnerable and poor. Why we are criminalising poverty and vulnerability is, in my respectful submission, beyond me. The Vagrancy Act of 1847 was brought in the middle of the famine to criminalise poverty. It was an ugly scene to see people starving on the side of the road, begging for food and begging for alms. And in actual fact, if you go to Hansard for the discussion of that piece of legislation, all of the MPs in Westminster from Ireland begged the Westminster government not to enact that piece of legislation, because they said it was a characteristic of this society that we provided alms to the poor. And yet it got on the books and it has never left. So our police can apply discretion. They can look at conduct if someone is being disorderly, if someone is using theft to feed themselves. There are ways of utilising the legislation that we've had for an extremely long time to deal with any problems that comes from a person who is homeless. The fact of begging, anybody begging, in my respectful submission, is actually a disgrace on our society. No one should have to beg. There will always be people who will beg, but they don't have to be brought before Belfast Magistrates Court or wherever, and eventually, because they beg so much, a magistrate or district judge with a really heavy heart gives them 1 week in custody. And that achieves nothing. It rehabilitates no one. It doesn't get them a house. It doesn't get them off drugs. So vagrancy isn't just a criminal justice system issue. It crosses a number of the departments of this government. But criminalising poverty, in my respectful submission, I'm glad to see the back of this piece of legislation.
No, thank you, and I totally agree. We shouldn't be criminalising social deprivation and poverty, and it's actually really helpful context. I wasn't aware of the context in which it was brought in, so thank you for that. And I think I just wanted to confirm then, in your opinion, that you don't foresee any unintended consequences from repealing this then?
I would prefer there to be intended consequences. So when we withdraw this piece of, when we repeal this piece of legislation, that there are alternatives for the police and civic society to deal with it. You only have to walk down Castle Street. My office is on Queen Street. You only have to walk down Castle Street to see that there is a failure of local government in dealing with what's happening in our city centre. That's not a failure of the people who are living on the street. It's not their failure. That's a failure of people who are involved in government and providing assistance.
I think the Law Society is trying to reassure also there in terms of if one takes it to a different level, apart from the vulnerability of individuals who'd be involved, ordinarily, if you look at the worst case scenario and somebody was acting inappropriately and the police felt that that was their only option, maybe to look at a begging situation, there are many other options for the police that are already there, such as disorderly behaviour, but even a common assault. You know, a common assault, which sounds quite dramatic, doesn't actually involve any physical contact. So if there was somebody who felt they were a victim of somebody who was in the street begging, there are many options without holding on to this.
That's really helpful. Thank you.
Thanks, Chair. Thank you, gentlemen, for your detailed presentation so far. Just to picking up on that point about the vagrancy issue, you know, I do think there is a wide recognition, you know, that it is a multifaceted approach and that's often the best solution. But I do think, you know, given nobody wants to beg on the streets, and unfortunately some of the people that are in that scenario, you know, they're not there, they're there maybe as victims, you know, including of human trafficking and so on. And I suppose I do feel, or do you, keen to explore from yourselves, do you feel that repealing this, you know, could be removing the tools to ultimately deal with, you know, maybe a criminal element further up the food chain as such, you know, who is maybe ringleaders of human trafficking, and it's often the victims that are out on the front line could fall, you know, to be the biggest victim of it. But
are you suggesting that by that question that, for example, there are foreign nationals, for example, who would beg in Belfast city centre, and is the implication there maybe, because I've no evidence of it, that they are maybe part of organised begging? Is that maybe
Coerced
what your
begging,
concern? Or coerced begging? Yeah, is that maybe the concern?
well,
Just clarity.
you know, I can imagine that can be the case. Certainly, you know, in various parts of the country.
Well, we have other legislation that deals with people being coerced, and those anybody who's standing on the street being coerced into begging is a victim.
Yeah.
And so arresting them for begging is not actually acknowledging, recognising their victimhood. In the same way as sex workers, we've now come in the principle that we now apply that they're the victims of the people who use them. So we have criminalised the people who use them, not the sex workers.
In theory.
In theory, and that's right. So in my respectful submission, it would be, I think, helpful to look on this from a different perspective, which is that people who are begging on the street in circumstances where they're coerced or part of a organised type of money-raising exercise should be treated as the victims of the people on up the food chain, and that the police have powers to go after the people who are on up the food chain, and so seeking the cooperation of the victims is more is of greater assistance than criminalising them, and that has happened with sex workers. Sex workers have now, not in large numbers, but there are sex workers who have cooperated with police in order to.
I think the issue here is if it's we don't think it's that straightforward.
No.
So, of course, none of us want to see people who are homeless and people who are in poverty criminalised. Of course we don't. Not for begging and for seeking help. The issue is to do away with the offence. 1, our council bylaw is enough. 2, if the police don't attend, which they won't do if no crime is being committed, and that person is a victim, that person is going to fall through the gaps because nobody is coming to see. They won't be able to have a chance to speak to an authority figure to say, help me, I'm in trouble here, I'm being, do you know what I mean? There's no opportunity, because it's the police then who make the referral. But if the police aren't going to come, where are we? Now, our issue is the police have said, yeah, we'll come, but we all know now, due to resourcing pressures that are not going to ease in any shape or form going forward in the near future, that if they're not turning up to crime, they're not going to turn up in this circumstance. So we're slightly concerned that there are people who are victims who could be more exploited. I think there are also aspects in terms of businesses. I had spoken to one of your colleagues at a Law Society event actually, who indicated that regularly, as he goes to open his business in the morning, there is somebody unconscious in the door. And part of the issue, certainly for me, is if you're going to repeal this, and I'm not suggesting you shouldn't, but I think it can't be done in a vacuum, because the support mechanisms need to be there to help people and to get them off the streets and to provide them. I mean, there are zero addiction services and help now.
Yeah.
You know, and that's the problem. It's the complete package, you know, rather than just moving out of what is the right thing to do, certainly, but it's not sufficient to do that and then leave all of this carrying on regardless.
But with respect, what I might suggest in response to that is that to keep it on the books because nothing is there to capture that person, it gives the opportunity to continue to criminalise people who should be captured in some other way. Taking it from the books creates a fait accompli, because someone will then have to take steps to deal with it. To leave it on the books leaves the opportunity to criminalise the vulnerable, whereas removing it from the books now creates an argument to say, once we had this legislation, now we don't, so what are we going to do about it? And it'd be great if by the time it was repealed that there was something in place to take it. That's on this specific aspect of the bill.
Mm-hmm.
Some focus should be put into the argument that you're making.
That's what we're trying to do. We're trying to explore this because, like, you know, of course you don't want to see this happen, but we're slightly concerned about there's other aspects of this. And to be honest, for the department to say council bylaws can deal with it, I don't know what your experience is, but I was on that. I mean, most of us have been councillors and we've seen how effective council bylaws are. If nobody's there, then the bylaws aren't enforced, and even if somebody is there, it's very difficult to enforce.
Well, they'll
them.
enforce dropping the cigarette,
But they don't.
but they'll not do anything about this. So I think if maybe we cared less about dropping a cigarette, by the way, I wouldn't encourage that habit, but if we maybe as a society thought more about that, about the human being on the street and not the cigarette that's been dropped beside the bin, then I think maybe we'd move forward on the problem and have something in place to capture people who at the minute are being criminalised by this particular provision.
It is difficult. I remember at a criminal justice event seeing a very powerful photograph which was significant spikes on the street, and it was to stop people sleeping in sleeping bags, you know. And it's similar maybe the other way around in this debate. And if you think it through though, on the ground, if the police, I get the logic of why you want to try and protect any way that somebody might get support, but on the ground, if the police are called to a begging situation, they have little choice but to either give them a token diversion or advice and warning even, or alternatively they then end up under arrest in the police station and they'll be taken to court, and if they don't have a bail address, they might end up in Hydebank or McGabbery then, and ultimately you would either get a number of days in custody or a fine or whatever. So I'm not entirely sure if you follow through with that concern that there's actually any real benefit
I think we need to figure out
the majority of people who encounter the police.
I think we need to figure out and get some stats around, right, what do the police do when they attend, you know, and is there consistency across the board, you know, how are they handling things? And I think that'll give us some indication as to.
There's other organisations who do impressive work on the streets who will in Belfast context, will drive up and down the streets and the alleys trying to, check, and they would be worth maybe having a discussion with also.
And the
what
street
they're-
teams and street pastors.
That's
and
right,
all that.
yes.
I think we probably need to have to hear from them at some stage. Would I say, Stephen, if you anything?
Yeah, that's
further?
okay at the minute, thanks, Chair.
Right. Lifelinks, in terms of the amendments, has anybody got anything there? Anything else from within the Law Society's paper? Any general points? Morris, I know you had a couple of general questions you had.
Got them answered
You're
to,
sorted.
to the presentations there. Thanks very much.
Does anybody have anything else in general that they want to cover?
May
while
I,
the
may I
gents will
raise
have-
one thing before anybody else?
Yes,
maybe?
of course.
It's because it didn't come up in the biometrics. It's the commencement of the retention period from conviction. Why is that not from the point at which it's obtained? I would respectfully ask the committee. Because there are, for example, if you are one of those people who will be subject to, say, a 5-year retention, and it takes 3 years for your case to be prosecuted and for you to be through the system, why do the police then get to keep it for 7 years and not a further 2? So this idea that it commences at the point of conviction with regard to some of these provisions, I would ask the committee to consider that and reflect on whether that should be from the point at which it's obtained. Now, if you're someone who waited, I have a client currently who has been subject to investigation, case still not heard, and it's 10 years later. And if you think about it, if that person was subject to a 25-year retention, we're 10 years into the 25 years, but if that person's convicted this year, that 25 years starts this year. And that, to my mind, sounds like a disproportionate infringement of their rights. So I maybe just want to flag that up before I left.
That may well be a question we can put to the department.
Was brought up as well previous.
Yeah, I think. We'll check. Are members content that if we haven't got an answer to that in our table, that we will seek an answer to that from the department so that we can understand the rationale and then make decisions of our own? Deirdre?
Also keen to see what happens in Scotland under that as well. Is there any, what the commencement is there? Just a cross-reference.
Does anybody have anything further? No? Gentlemen, can I thank you very much. You've been very generous with your time, and your answers been really helpful for us to see the practical aspects and to give consideration to those. Do you have any update on Brian or anything? Or?
No, I was just checking to see if we'd received anything, but thank you for the patience earlier as well.
No, of course, and look, please pass on our very best to him. Brian's been in front of the committee numerous times before, so we know him, and please pass on our good wishes to him for a speedy recovery. Thank you very much indeed. Thank you.
Very much.
Members, in terms of follow-up there, we've agreed a couple of things that we're going to check with the department. I think we've agreed a few people we'd like to hear from that can be added into the gaps that were mentioned there, the street pastors, the street teams, in terms of repeal of vagrancy. We had a couple of councils. And so is there anything else we want to follow up immediately as a result of that session? Kathy, do you want to say
Yeah, sure.
something?
You mentioned stats around what the police do when they attend
Yes. So whenever,
instances of begging. So
yeah.
Okay.
So
You want to straight to the
I
police
suppose
on that then?
well, it's not necessarily even just stats. It's about, okay, what's the approach? When do they go? What's the approach? Is it consistent across Northern Ireland? What are the outcomes? What do they do when they're Danny?
Just out of curiosity, as a new member, has there been evidence given that there is, is there evidence that there is organised crime behind organised begging?
I think we should look at
Have
that
we
too. Well, and I think that's part of the stuff that I think would be helpful if we hear from Glasgow and Aberdeen, who objected initially, and it's been, but obviously that law was implemented. Have their fears been assuaged? Is anything happening there? I think we can learn from there to see. Okay, well,
I
what's
haven't missed
going on?
any. That hasn't been part
No.
of any evidence or anything.
No. No. I think it'll be useful for us to understand. So our members agreed to that?
Mhm.
Yeah, thank you very much. Right. I think that was a really useful session, actually. Now, I just need to find where I am in the brief. Right, okay. Members, that takes us to agenda item 6, which is the budget, 2025-26, main estimates and estimates memorandum. There's a written paper from the department at page 360 of your pack. So the department has provided a written briefing of the main estimates and the main estimates memorandum for 2025-26, and that's been submitted to the Department of Finance. Are you content to note those papers, or do you have any questions or require clarification on any point? Content?
Content, yeah.
Content, thank you. Agenda item 7 is improving health within criminal justice strategy and action plan. It's a progress report. I'd ask members to turn to page 375 of the meeting pack for the relevant papers. You'll see there the department has provided a written paper advising that it plans to publish a progress report on the improving health within criminal justice strategy and action plan. And the report also outlines a number of options for the future direction of the strategy. Are you content to note the papers and consider the matter further when a decision has been made on the way forward? Do you require any further information or clarification? Any points you want to make on that, Ciara?
I have a series of points I can follow up, but obviously the report itself and the progress report, some really fantastic work and excellent work that has been done between the Department of Justice and Health, but there's a number of really outstanding ones. Particularly, I would be seriously concerned about the conflict currently or the dispute, would I say, between both departments on who's responsible when it comes to social care, and the fact that there is people not receiving social care. That's a big one, and neither of them have commissioned anything for it. And there was, I'd love to see the copy of the original report that was done, and the recommendations were given to both departments. But both departments rejected the recommendations based on value for money, so it would be really useful to get a copy of that. Likewise, in relation to, and we've, in the visits to the prison, and I know we've had various conversations around support for those with personality disorder, and that's a key one for me. And I see that there is now an outline business case for personality disorder settings, and it's in its final stages of development. So even if we have a caveat, the asset department as and when it will be useful. And I know we're going to follow up and do a joint committee, but these are a range of questions that we could send in advance.
Yep.
So make it really, really useful. Likewise, the accommodation, and we've had various discussions regarding the lack of accommodation that is available. And they've recognised there is serious limitations because they don't have a responsibility, and it is the department. So I suppose there's a lot of work, ongoing work that needs to be done there. And I know we have fantastic supporting people that do amazing work through DFC and the funding that they provide. But it was very weak in what is available, what is support, what's the difficulties in the final report that they gave. Likewise, in relation to, seriously, we all know the total lack of the bed management for the acute psychiatric beds. They're saying the waiting list is still too long. So I'd like more information on what is the waiting list, what has been, how long have people been waiting, how many people have waited, because that's huge, massive. And I'm also concerned across the overall report that there's a lot of key good work that was happening, but it's kind of transferred over. You know, they continuously say it'll be under the mental health strategy now, and we're well aware of, I suppose, the limited investment that's gone into the mental health strategy, and it's already in operation and it's there for 10 years. So I'm just fearful. I think it's critical that we have discussions regarding what the next steps is, and I know the task force gave us 4 options of what's the next steps in relation to this, but I think in our joint committee with health, I think we should be all having discussions on it as well in relation to what them options should be. And then, look, there's a number of other ones as well regarding the forensic medical officers, obviously working in police custody, still don't have access to the health data for those detained in custody, and that was per recommendations from the Criminal Justice Inspection report. So, you know, what is happening there? What's going to, you know, is that going to change? The crisis model, some fantastic work has happened with the crisis model, but it is pilots. So between the three, and obviously they did mention we're well aware of the multi-agency triage team, and I know that's we'd love to see that rolled out further across the whole of the north. At the minute it's 80%, but there's a further 20% of detainees that don't get access to that.
We're going to stop funding that.
What?
Do you remember this, Marcia, the policing board? They were going to stop funding it.
And then we have the ambulance service, and we're aware of that. And then obviously we had the joint committee where they done the presentation on the right person at the right time model. So where is that all happening? And I'm just fearful as well into the future it could get lost. So that's another one. The AD, there's a lot of research, so they've done a tremendous amount of research, which is great. But I'd love to get a copy of the police custody health needs assessment that's just been completed there at the end of last year. So I think that would be useful just for our own knowledge of the needs, because we're hearing, we visited it would really good to just see an overall analysis of the health needs. And then likewise, I just welcome the ADHD overall regional report, but they are going to focus on the prison population. So maybe I would love to find out when it will be available, and if and when that we're made aware of it. So that's a number of, I think, the key areas that come out from the report. And if we could get further information on them prior to us doing the joint committee meeting with them.
I think, to be honest, this is sufficiently grave that we may want an oral briefing. To be honest, what struck me was that there are paragraphs in this, particularly 6.2 to 6.5, it's just an indictment. And, work wasn't progressed, and I understand why it's not. However, now a whole pile of the stuff has been superseded by other strategies. People are being pulled away. There's no resources. So, this is just a mess. In my view, and also in terms of the questions, if we can add one there, paragraph 811, delay in progress has been mainly due to responding to pandemic priorities and external work commitments. What is that? And I think we need to understand this. I also think that this report needs to go to the Committee for Health.
Yeah.
So they can see and they can be following up some of this stuff, because it's not always not just within our remit, and you can see even the disputes over who's the lead, that some of these things weren't progressed because they couldn't agree who was the lead. So I'm also conscious, this area of work is something that the committee has indicated as a priority for it, the mental health aspect in the criminal justice system. So I think we'll end up coming back to this report as we progress that work as well. So are members content that we would forward those questions to the department in the interim period, and we'll give consideration as we move through the other work to return to this report and maybe an oral briefing. Yeah.
Yep.
But further down the line, I think, whenever we return to our prioritisation rather than the bill. Yeah.
Yep.
Okay, thank you. Agenda item 8 is sentence reduction for guilty pleas consultation. It's a written paper from the department. It's starting at page 429. The department's provided a written paper advising of its intention to launch this public consultation on sentence reduction for guilty pleas, and the plan is to launch the consultation tomorrow. That'll run for 8 weeks. I think the idea is that it closes on the 11th of July, which I don't think is an ideal date, to be honest. A copy of the consultation is included in members' packs. You can tend to note these papers on the consultation document and consider the matter further when the results are known and the way forward is available, or do you require any further information or clarification?
No, just agree to that and reserve judgment until we see the responses.
Agenda item 9 is correspondence. You'll see there's a correspondence memo and 5 items of correspondence starting at page 470 of the pack. Let me just get that open. Right. I'm going to draw your attention to one item, and then I'll open the floor so that members can comment on anything else that's drawn their attention or in which they've got a particular interest. Item 9.4 is correspondence from the Public Accounts Committee to the Policing Board at pages 478 and 479 in the pack, and that's in relation to the Northern Ireland Audit Office report and the PSNI fleet management. Can I ask your agreement to request a copy of the Board's response to the PAC on that, please?
Yep.
Does anybody have anything further that they wish to raise from within the correspondence?
Oh, just in relation to, just double check, the response from the Department of Justice regarding the NI search and rescue. Just to say, obviously, we welcome the review that's going to be held. I suppose that's basically it. Just obviously, we're well aware. I raised the concerns, particularly just regarding the process, and it felt like a closed shop regarding individual organisations and the amount of money. So that's kind of been made a wee bit more clear. But I think I welcome the review. They say that they're treating it as urgent. So if that's the case, I would like the time frame.
But they've said there is no time frame. It's just being prioritised. So the other thing slightly worries me is £100,000 doesn't increase in the event of other organisations being admitted, which I think is a disincentivization to admit people.
Yeah.
But the other thing is the application process is not automatically assigned to organisations by virtue of being a member of NICER. So it's an application process for funding. So presumably that funding is not evenly divided. So how do they determine the basis on which funding is allocated? What's the criteria? Be helpful to have some understanding of that, and whether that is under review as well.
Mm-hmm.
Members agreed to that?
Yeah,
Yeah.
great. Sure.
Does anybody have anything further in correspondence?
Just on that point, Chair, could we find out how the training takes place for all those organisations, just to make sure that they're all qualified to the same standard? We can
Yes.
find that out.
Yeah.
Members content to ask that?
Yes.
Yeah. Yes, Marsh will do that. Anything further in correspondence, or is that it? No? Okay. Item 10 then is the Forward Work Programme. You'll see that is at page 488 of your pack. Can I seek your agreement to on the Forward Work Programme, subject to the changes that may be necessary as we try to seek people's availability and so on? Yeah.
Agreed.
I want to flag up one issue, which is about the PACE codes that are coming next week. Obviously that's sizable documentation. The department is keen to get those codes introduced and implemented. And there's a rolling programme, because those are going to have to be updated again after the bill and all the rest of it. So this is kind of, the PACE codes are a rolling programme. In order to assist us, the official who's responsible, who's Lisa Bowl, who's been in front of the committee previously, Lisa's going to be in the gallery. So that if we've got queries, Lisa's here to answer them directly, so that we can try and get this over the line.
Good, yeah. The expedited,
All right.
sure, yeah.
Yeah, because I don't think, look, we'll always have questions, but this is not our last bite at this cherry, I think is the point I want to make in that, Cathy.
Chair, sorry, if I could just ask if any members do, between now and next week, have identify any particular issues that they might want to raise with Lisa. If they could let me know, and then Lisa can do her best to prepare in advance as well.
No problem.
All right. Agenda item 11 is chairperson's business, of which there is none. Agenda item 12 is any other business. I don't have any. Does anybody have anything? No. Item 13 is date, time, place of next meeting. That's going to be in this room on Thursday the 22nd of May at 2 p.m. The meeting is adjourned. Members, thank you very much.
Committee Room 30, Sound.